CO.
Oh, CO, revisional application.
Revisional application.
Whether the court does not have determination, which year matter?
2015, Lordship.
2015.
15.
And this revisional application is this. You see, up to anyway. Anyway, let it give the slip. It will appear on Monday.
Lordship, may I be permitted to mention one matter? Item number 77.
Set the list first. Yes.
Lordship, may I permit to mention for discussion, Lordship.
Hearing, claim case hearing.
Wait for hearing, Lordship.
Yes, after 2 weeks.
Not for appearance to be mentioned for deposit of check.
Yes.
Lordship. Item number 77 from today's list, Lordship. Today is the last date of interim order, Lordship.
Item 7.
Item number 77, Lordship.
Anyway, intimate the other side.
Yes, Lordship. I served the notice, Lordship.
You have served notice.
Yes, Lordship.
You have served notice that you are going to mention for extension.
Yes. Yes.
Yes, record an order. Yes, 77. Learned advocate for the appellant is present. As this matter cannot be taken up today, the matter stands adjourned. As the interim order will expire today, the same stands extended for a period of 5 weeks or till further orders, whichever is earlier.
Grateful, Lordship.
May I have my Lordship?
Usual could say.
May I have my Lordship kindly to mention item.
Let the matter retain its position.
May I have my Lordship kindly to mention item number 8 of my Lord's today's list. It is fixed at 2 o'clock. Lord, I am one of the respondent in this case. Mrs. Mukherjee, Lord, is for the appellant. Mrs. Amit Ranjan Roy is for the claimant. Lord, I have called them up. Lord, at 2 o'clock, I am in some difficulties. Lord, will take it up. Lord, it won't take more than 5 minutes. It may not subject to Lord, their
not today.
Lord, not today, Lord. Not subject to Lord, their comfort, Lord, and pursuant to my Lord's Lord, the pleasure. It can be taken up tomorrow or even on Saturday. Lord, Saturday they all are coming. It will not take more than 5 minutes, Lord.
Achha.
Lord, whenever they are comfortable, Lord, I am ready to do the matter.
Let this matter.
Lord, let them come, Lord, let them come. They are not here, but Lord, your Lordship will kindly remember this, Lord, whenever they will come.
At 2 p.m., I shall record the order.
Yes, Lord, since I would not be here, Lord. Yes, yes, yes. Yes. ওরা নেই তো এখন তাই জন্য ওরা বলবে ওনার হ্যাঁ 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 আমি কথা বলে দিচ্ছি grateful to your Lordship.
Inclusion for
extension of interim order is there.
Under the heading what? Application?
Yes.
Yes.
Yes, sir. Milord, I beg to appear on behalf of the respondent. Milord, on this.
You are for the Union of India.
Milord.
Yes, who is for the appellant?
Last day there was a direction for serving us as a copy of the paper book that we have filed.
Paper book is filed by you or filed by the other? So they have not appeared today.
They have not appeared today. Last date they were there. Milord's passed a direction for serving us. Nothing.
Achha, record an order. Let this matter appear on 11/8/2026 under the same heading. Learned advocate for the appellant who was required to serve the paper book be intimated in the meantime.
Kindly make it passes over. Mr. Ponik is appearing on behalf of the appellant.
13.
12 is for, I'm sorry, 12 is for extension of time.
Okay. Item 12, record an order. Learned advocate for the
না 12টার extension of time আছে আমি তো
learned
মিস করে
advocate for the respondent
ভাবলাম না
insurance
একটু
company
উপর
is
থেকে আরো
present. It is submitted by learned advocate for the respondent insurance company that the time to deposit the compensation check
Lordship has expired.
has expired, and due to certain difficulties, the check could not be deposited. Thus, the time to deposit the said check plans extended till 5/8/2026.
My lord, by 1 week.
5/8.
5/8. Extremely grateful to your lordship.
Item 11. আচ্ছা item 11 এ অর্ডারটা রেকর্ড করুন তো। Learned advocates 11 এ যেটা করেছিলাম ওটা কেটে দিন। Learned advocates for the parties are present as the paper books have been filed and the matter is ready for hearing. Let this matter appear on দেখুন কবে আছে। 12/8/2026 at 12 p.m.
My lord, will kindly pass.
Okay, pass over.
My lord, I am for the applicant. My lord, order has already been, award has already been passed. But one thing, after marriage, their surname has changed, Sao to Devi. That is one thing. Another thing,
So did you take out any application for that?
Uh,
Item 14.
14, I have for correction.
Anyway, record an order. Learned advocates for the parties are present as there are certain developments pursuant to the appeal being disposed. Necessary applications may be filed. List this matter after 2 weeks.
Already matter
Grateful
for
to your lordship.
correction, the
Yes, but how can I record the developments unless there are application, unless there are documents?
application, I have already filed
You
application.
have filed that application.
Yes, yes.
So let this application be,
No, I have filed, this is the copy of the application.
application টা নেই কেন লিস্টে?
My lord, kindly see page 4, para 4, para 5, para 6. Page 4, para 4, 5, 6. The address changed and surname changed after marriage. This is the position.
Yes, let it be taken up by consent. This application, you have been served with a copy
Lordship, I have been given something just now, my lord.
with regard to correction.
My lord, if my lord is convinced, my lord, I don't have any problem.
I have filed the Aadhaar card also, my lord. All the claims I have filed.
Aadhaar card is not given to me. I don't know whether he has filed or not.
Okay, I just make it not today. Serve him a copy.
কোথায়? তো
Yes, let this matter appear under the heading application on. Just I'm making it not today.
thank you very much.
Pass over.
ঠিক।
Fifteen lordship signed. Lordship paper book already submitted. Earlier also this matter fixed, but somehow not listed. Not
Yes, learned advocates for the parties are present. আগে ইয়ে ছিল, the matter was heard earlier.
Not lordship, yes, 163A application,
No, matter was heard earlier.
not heard. But
Acha.
lordship, this is 163A
Advocates
application,
for the parties are present
third date lordship. Earlier also.
as this matter is ready for hearing and the paper books filed. Let this matter appear for hearing on যে কোনো দিন দেখুন 4টের সময়।
Chart notes and code lordship.
163A, it will not take much time.
Lordship.
163A, it will not take much time.
Lordship, sometimes 3:30.
10/8/2026 at 4 p.m.
Not lordship, 10.
2 p.m. বলছি।
No, 10.
No, 10th you have some difficulty.
Yes, lordship.
আচ্ছা দেখুন অন্য কোনো ডেট আছে কিনা।
11 is all right.
11/8/2026 at 2 p.m. 4 p.m.
Lordship, 2 p.m. 4 p.m. lordship, if 3:30 then.
Okay, I shall on the next day I'll accommodate you.
Lordship, they are, it is also hard time lordship fixed. Careful, lordship. It's only 3 p.m. maybe.
Yes.
My lord, I am led by Mr. Subir Banerjee. I am respondent or claimants. I am matter is ready. Now I am filing paper book.
Yes, learned advocates for the parties are present as the appeals are ready for hearing and the paper books filed. let this matters appear for hearing on, দেখুন,
My lord, any day at 2 p.m.
11/8/2026.
আরেকটু পরে অনেক মামলা মুশকিল হয়ে যাচ্ছে।
My lord, 2 p.m.
13/8/2026 at 3 p.m.
My lord, 18 is the insurance appeal. My lord will kindly fix up, my lord, a date for hearing, my lord.
Paper books
Paper
are
book
filed.
has been filed.
Yes, item 18. You are, who is appearing for the respondent?
অনেকগুলো মামলা আছে। My lord, Mrs. Ghosh is appearing.
Okay. Learned advocates for the parties are present.
প্রথম মামলা কি?
As the matter is ready for hearing and the paper book file, let this matter appear for hearing on 13/8/2026 at 3 p.m.
Obliged, your lordship.
Well, not today.
My lord, I am for the appellant.
Yes.
It's for correction, my lord. Only minor correction, my lord. Point number 12, last line of judgment. No, judgment last line, my lord. Point number 12.
Yes.
Upon depositing being made, the appellant's claimants will be entitled to withdraw. It will be appellant claimant because memorandum of appeal and judgment is
Okay.
in the name of Bhuvneshwar Thakur.
Learned advocate for the appellant is present.
And one more thing, Honor, it should be mentioned, they are saying that appellant claimant Bhuvneshwar Thakur will be permitted to withdraw the.
The matter is put up for necessary rectification and correction and clarification of order dated 3/2/2026. In order dated 3/2/2026, in paragraph 12, page 7, it is mentioned upon deposit being made, the appellant's claimants will be entitled to withdraw the same. But the same should be corrected as appellant claimant
Bhuvneshwar Thakur.
Sri Bhuvaneshwar Thakur. Other contents of the order dated 3/2/2026 remain unaltered.
My dear, but let's see, I for the appellant. Last occasion hearing, then now the stage is written notes of submission for written notes of argument. Let's see, there are any difference.
So, are you all ready with the written notes?
Written notes are already.
Let me see the last order.
Mr. Mukherjee, Bobal Mukherjee appeal this matter, Lordship.
Let me see. So the matter was posted on 20th July. Thereafter, it did not appear. এর আগে তার আগের 20 তারিখের অর্ডারটা দেখি
20th July, Lordship, that matter is not a daily
not
list.
taken up on
The-
20th July.
The 21, the list, the daily list, the matter is not appeared the daily list, Lordship.
So,
The subsequently list was published. Supplementary list of I have not.
question is the matter hearing is concluded in this matter.
Lordship, last occasion, Lordship, direction to file written short.
Where is the direction? Let me see.
Notes of
Oh, there was a direction that the matter will appear for further hearing and learned advocates are requested to come with written notes.
No,
of
no,
argument.
Lordship, that is stage.
So you are appearing for?
Appellant, Lordship.
Okay, let it appear for final hearing.
Lordship, short date, Lordship.
learned advocate for the appellant is present. একটু shorted দিন, এটা hard হয়েছিল. As this matter was heard earlier, let this matter appear. Let this matter appear for final hearing on 17/8
17.
17/8/2026 at 2 p.m.
As a heading of final hearing.
Yes, yes.
It is extension of time to deposit.
Appeal has been disposed of.
Yes.
Further, yeah. Set up
Yes, record. Learned advocates for the parties are present. It is submitted by learned advocate for respondent insurance company that the compensation check could not be deposited in time and prays for extension of time to deposit the check. Stop. Thus, the time to extend the time to deposit the compensation check stands extended till 6/8/2026.
My lord, for 23, I'm for the respondents, my lord. I'm for the respondents, my lord. I'm led by Mr. Kushal Chatterjee in this matter. My lord, on the last occasion, there was a direction upon the appellants to file their condonation of delay application, my lord. That has not been done.
Yes, you are for appellant.
Yes, my lord.
What was the order passed last week?
My lord. This
Begin.
হয়ে গেছে my lord, if I may submit, my lord, there's probably been a miscommunication from the department.
No, actually, you see, on the last occasion, there was a direction that there is a delay of 23 days, but no condonation of delay is filed. So the matter was adjourned for you to take steps.
My lord, if I may submit, my lord, the condonation of delay was not only filed, the condonation of Section 5 application was also condoned, which is available in the first order passed by the division bench, presided by Honorable Justice I.P. Mukherjee. My lord.
Let me see this.
If your lordship is,
You are representing all the respondents.
My lord.
Let me see. That is
my lord, it's an order dated 19th December 2022, my lord.
My lord, one more humble
Yes,
submission. my lord.
19th December 2022
Yes, my lord.
at 1:37.
জানি না, আমার কাছে কোনো খবর নেই।
Yes, record an order.
My lord, one more thing.
Yes,
We have heard from the neighbors, my lord. These are our instructions I'm submitting.
Yes.
That the appellant has died.
okay. You will take instructions.
Very well.
Sole appellant.
Yes, my lord, so
Sole appellant has died. You take.
my lord, allow me to come back with instructions where I do.
Yes, record an order. Learned advocates for the parties are present. As the delay in preparing this appeal was already condoned by order dated 19/12/2022, and the appeal was admitted by the said order. Let the informal paper books be prepared in accordance with the direction issued by order dated 19/12/2022. Let this matter appear after 5 weeks.
If you please.
My lord, I'm for the respondent, my lord. My lord, in this matter, the Section 5 application was allowed subject to paying of costs to the respondents and legal aid. But my lord, the respondents, we have received the cost, but whether the legal aid has received the cost, that I don't know, my lord. I know the
Don't
last
know.
occasion also they didn't appear, the appellants. It was made not today. And on the last occasion, the deposit of cost was extended till 10th of July, and we have received on
No,
8th
that you have received, but whether the,
legal aid has received or not within 10th of July. That is to be ascertained, my lord.
okay, I'm just making it not this week,
My lord, on the last occasion also they didn't appear, my lord.
because you have received the cost.
My lord, kindly record an order, my lord. They're just
On the next,
Delaying
if
the-
they don't come, I shall pass necessary orders.
My lord, make it just a last chance.
You can also ascertain from the legal service authority. If it is paid, then it is okay.
25, my lord, I am paying not today, my lord.
Okay, not today.
My lord, I am for the respondent. My lord, in this case, Tajul Hasan Jomadar or Hossain Jomadar. Only mistake the alias name I should be included.
The cost title
My lord. My lord,
is can too.
Can too. Yes, my lord. Para 3 I have stated. Para 2 and 3 I have already stated. I have filed the
No question
bank
was
account.
this person was not included within the.
Yes, my lord.
Why?
By Hasan or Hossein, spelling, only
Name-
spelling,
Name has to be
only
corrected.
spelling. Hossein Hasan or another. I have stated in para 2 and 3. HOSSAIN, it will be alias name, would be.
Okay, Tajul Hussain. Oh, LSM. Yes, record an order. Hey. Learned advocates for the parties are present.
The alias name.
The application is filed for rectification of the name of the claimant, respondent claimant, Tahajul Hussain Jamadar. It is contended that instead of Tahajul Hussain Jamadar, the name be recorded as Tahajul Hussain Jamadar alias A. Tajul Jamadar. Stop.
Alias.
Thus, this prayer is allowed. The rectification and amendment be made in the cost title within 2 weeks. And Tahajul Hussain Jamadar be recorded as Tahajul Hussain Jamadar.
Hossain Jamadar.
Tahajul, you have rated HASSEN.
But it will be HOSSAIN.
HOSSAIN.
AIN,
Tahajul,
yes.
HOSSAIN Jamadar. Let it be recorded as TAHAJUL HASSEN JAMADR alias Tajul Jamadar alias Tahajul Hossain Jamadar.
Yes, ma'am. Yes, my lord.
The amendment will be carried out within 2 weeks.
Macho. কি বলছো? দিচ্ছি ঠিক আছে
Hello, kindly see the last order. Earlier question matter was heard 9th June. Thereafter matter was taken 22nd.
Okay, let me see the order.
But unfortunately not in the list. Thereafter again mentioned.
You are for the respondent.
Lordship, I'm for the appellant too.
Kindly fixed for hearing any day.
Matter was heard earlier.
Yes, hard and fixed. 22nd July, but unfortunately not in the list.
Yes, learned advocates for the parties are present. As this matter was heard earlier, let this matter appear on 17/8/2026
At 2 p.m.
at 3 p.m.
All right.
My lord, I am appealed for the appellant insurance company. My lord, it's a 163A case. My lord, already it has been heard. My lord, let it be placed for final hearing.
I am for the claimant respondent.
Yes.
Paperwork has already been filed.
Is this matter where you said it is 90 years age?
No, this is
No.
not that matter. This is appearing what a
This is 163A case, my lord.
Yes, learned advocates for the parties are present. As this matter was heard earlier, let this matter, shall I keep it this Saturday?
Yeah, sir, no, my lord. On 17th, lordship, 17th.
Let
August.
this matter appear on 17/8/2026 at 4 p.m.
No, not my lord. 2 p.m.
There are
lordship.
other matters fixed.
Lordship 2 p.m. Lordship may kindly fix up 2 p.m.
Okay, 3 p.m.
I'm grateful, my lord.
On
17-8.
and that matter is 152.
17.
So whatever your lordship is saying, that is 152 of today's list.
Okay.
90 years.
I'm grateful, my lord.
I'm appearing.
Well, this is, well, appeal has been
29
disposed of. I
appellant.
prepared one
29.
application, filed one application to, my lord, correct the name of the respondent number 1.
This matter was disposed of, my lord. Money is already lying deposited before my lord's.
Yes.
Now he has
Oh.
come for correction.
My lord, kindly see page 17, my lord. Page 17. Page 17, my lord, that is the name of claimant. My lord,
Asghar Ali Lashkar.
yes, Asghar Ali Lashkar, AJGAR.
And
Thereafter, my lord, kindly see 18, also, my lord, Asghar Ali Lashkar. Thereafter, my lord, the PAN card is also Asghar Ali Lashkar.
the claimant's name in this
In
petition.
the, my lord, I am coming. Thereafter, my lord, bank account also Asghar Ali Lashkar, and in the claim petition, it has been written Mohammad Asghar Ali alias Asghar Lashkar. My lord, I am praying before your lordship, kindly record the name Mohammad Asghar Ali Lashkar as alias Asghar Lashkar alias Asghar Ali Lashkar. My lord, kindly see page 22. I have page 22, that is the, my lord,
Okay, affidavit.
affidavit, first class magistrate. The person is same and identical. And my lord, in this case, my lord, since the bank account has been recorded as Asghar Ali Lashkar, my lord, check may be issued in the name of Asghar Ali Lashkar, my lord.
Yes, record and order. Learned advocates for the parties are present. This is an application filed by the claimant for rectification of his name in the cause title. The claimant respondent has filed the PAN card, voter identity card, and the Aadhaar card, wherein it appears that the name of the claimant is Asghar Ali Lashkar.
Yes.
Even in the bank account, it is Asghar Ali Lashkar. Stop. Thus, the cause title of the memorandum of appeal be amended and rectified, and Mohammad Asghar Ali alias Asghar Lashkar be recorded as Mohammad Asghar Ali alias Asghar Lashkar alias Asghar
Ali Lashkar.
The application stands disposed. Let the amendments be carried out within 2 weeks.
And my lord, check may be issued in the name of Asghar Ali Lashkar, my lord.
The compensation check may be issued in the name of Asghar Ali Lashkar as appearing in the PAN card and Aadhaar card.
Grateful, my lord.
I'm deeply obliged, my lord.
Matter was fixed on 14th of June at 12 p.m. That could not be heard about that.
কি করে পেপার বুক আজকে দিচ্ছ 14 জন কি করে ফিক্স থাকে পেপার বুক তো দাওনি কোর্টকে
Yes, learned advocates for the parties are present. As this matter was fixed earlier, let this matter appear on 18/8/2026 at 12 p.m. The paper books filed be kept with the record.
obliged to my lord.
Eh? 34 to 37. 34 to 37.
34 to 36.
37, my lord. It's
34 to 37.
the correction, my lord, is only in respect of item number 36 and 37. It's analogous. All the cases are analogous, my lord. Can 2 is my application for modification. The
Correction.
can 2 টা file না 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 ওটা মডিফিকেশন ফ্রেশ ফাইল করা হয়েছে। Can two? FMA 1421. জুলাইয়ের গোড়াতে জুলাইয়ের গোড়াতে My lord will kindly take my
Malord kindly take.
My lord kindly take his copy, my lord. কত 107 না
অ্যাপ্লিকেশনটা নেই নাকি?
এটা
The paper book also, my lord, will take up once. The award, my lord, what the judgment that my lord had passed, the amount of compensation, my lord, that will reduce a bit. There had been certain errors. In my CAN application, my lord will kindly come to annexure B, last but one page, page 24. This will be the calculation.
B.
Annexure B, last but one page.
What have you prayed for in your petition?
My lord,
Paragraph 7.
my lord,
What have you prayed in?
I have prayed for correction, my lord. That is at paragraph number 7. That is at paragraph number. My lord will kindly see. Annexure A is the order copy. Annexure A is it's at page.
21.
My lord is going through my application. It starts at page 9. I'm sorry, page 8. And the calculation, my lord, these are all analogous cases. The calculation, my lord, is at page.
So earlier it was rectified, 17/6/2026.
Yes, it was rectified by my lord, but since this amount will change, my lord, that is why I filed this application.
So earlier it was total compensation came to how much?
My lord, actually this appeal has been dismissed by your lordship.
Yes.
Actually, what happened, my lord, kindly see paper book 107. Your lordships will find.
So let me see the order.
Yes.
The order, my lord, the learned trial judge had granted an amount of 2 crore, 10 lakh.
Post judgment.
Yes, my appeal.
Modified to the extent that respondent number 1 claimant is entitled to compensation of 11 lakh.
No, that is in the other FMA. That is in FMA 527. This one is FMA 1421.
Yes.
In that,
141.
my appeal was dismissed.
Okay.
So that 2 crore and odd was the claimants were allowed to withdraw that, but that amount will reduce, my lord. Why I say my lord will now kindly take up the paper book in 1421 once, page number 107. Paper book একটু দিন না 14-21
paper book.
নাহলে আমারটা দিয়েও দিতে পারেন, এটা ইজিয়ার হবে।
এটা দিয়ে দিন, এটা my lord, kindly see the right hand portion. That is the salary slip that has been proved. My lord, kindly see the gross salary. Your lordships will find that the gross salary is rupees 14,144,000.
Yes.
And my lord, kindly see the less income tax. Yes, my lord, kindly see income tax has been given. Tax on total income is
94,475.
Yes. And tax payable.
So that is what I have done at page 24, my this annexure B, my lord. And accordingly, it will come down to 1 crore 96,33,035.
Yes, my lord. Actually, at the time of calculation, the tax amount will be deducted. That is settled law. My lord, I am admitting that.
1 crore 96.
Yes. 35. This will be the amount.
Okay. Even if the trial court's order is.
Yes. That is the no. Upheld to some extent, but it will come down. Calculation is wrong, and I have taken these rounds in my memorandum of appeal. The income tax was not deducted.
Trial court not deducted any tax.
Matter these appeals which were heard analogously were disposed by judgment and order dated June 9, 2026. Stop. Pursuant to the disposal of the appeals, learned advocates for the parties have detected certain mistakes with regard to the arithmetical calculation in arriving at the compensation amount. by the learned trial court.
Yeah.
Thus, the said arithmetical calculation is furnished in details in page 24 Annexure B of the application. As it is submitted by the learned advocates that the total compensation comes to 1,96,33,035. The appellant insurance company shall the respondents claimants will be entitled to compensation of rupees 1,96,33,035
My lord.
Along with
From-
my lord interest.
along with interest at the rate of 6% per annum from date of filing of the claim case till June 9, 2026.
And I'll also be granted the liberty, my lord, to withdraw the balance
My
amount.
lord, till payment, my lord, actually, my lord,
So
till
earlier,
realization.
you see, main order I have stated till, you see,
My lord.
that date. No, as per the order of the trial court, it is till realization.
Till realization.
That I have not modified.
My lord, my lord. That-
Okay. One crore 96,33,035 from the date of the filing of the claim case till date of deposit.
Till date of realization, my lord.
No, no,
Kindly-
date of
Till
deposit
today, my lord has written till today, that is the earlier order.
till today. No,
Page
in-
20.
No, no. So far, this appeal is concerned. 1421.
In the event is not made,
142,
claimants
that
will
was-
withdraw the, if deposited. The entire deposit, they were allowed to withdraw.
So
So there was no modification there, but now since it is being modified,
only the quantum,
quantum,
not with regard to the interest and all this
Yes,
thing.
yes, yes.
no.
Only with the principal quantum.
Then
If excess amount is there, my lord,
any
that will
excess
be-
amount, I'll be,
So
till realization, the difficulty, my lord, the difficulty, my lord will hear me once, my lord. Difficulty till realization, my lord, it's not, we are not
date
sure
of deposit.
till the date of deposit. No, that, তাহলে তো মুশকিল হবে, because we have deposited extra. Till today, let it be till today.
No, today means it should be date of judgment.
Oh, since it's modified, my lord, today my lord is modifying, let it be till today.
Filing of the claim case till today. The balance amount, the balance, the residuary amount, if any, be returned to the insurance company upon compliance of necessary.
I'm so grateful, my lord. আরেকটা বাড়ি বানাবে। ও 39 তো আমার
This matter I am appearing on behalf of the claimants respondent.
ফিক্স করিয়ে নিন।
পেপার বুকটা আছে আগে দেওয়া
My lord will kindly fix up a date because this can be disposed of.
Vehicle owner.
vehicle owner.
So the matter has to be fixed for hearing.
My lord.
Learned advocates for the parties are present. As the matter, was this matter heard earlier? As this matter is ready for hearing and the paper books filed, let this matter appear for hearing on 18/8/2026. দেখুন 18 তারিখে at 12 p.m.
My lord. I'm grateful, my lord.
No, দেখো Well, the paper book is not there, my lord. I shall submit a copy of the papers.
So paper books has not filed.
I am not sure, my lord. একটু রিপোর্টটা দেখুন না। তাহলে আমি পেয়ার বুকটা দিয়ে দেবো।
পেপার বুক ফাইল হয়েছে কি? The order will remain. You have soft copy of the paper book?
Yes.
Yes.
18 আর দুপুর 12টা। আমি সার্ভ করলাম। নোট করলাম।
Item 40, my lord, I am appealing on behalf of the appellant, my lord. Appeal is ready for hearing, my lord. Paper book has been filed, paper book has been served. And my lord, this is against the dismissal of the claim case, my lord. The claimant has been suffering, my lord. Payment, this is the case of it. Kindly fix the date.
163A or
No,
160?
160.
Yes, learned advocates for the parties are present. As this matter is ready for hearing and the paper books filed, let this matter appear for hearing on 10/8/2026 at 12 p.m.
10.
এক মিনিট 10 তারিখে আবার আমি মানে না
I am for the respondent. I am for the appellant, my lord. In this case, hearing was concluded from both sides.
so only you have to file written notes of argument.
I am
Yes, record an order. Learned advocates for the parties are present. As the hearing is concluded and the written notes filed, let this matter appear for judgment on 17/8/2026.
Grateful, Lord. I am for the appellant.
42, yes.
Lord,
You are appearing for?
Union of. My lord, there are so many dates fixed for the fixed matter. But unfortunately, it is not hard by.
I make it not today only. On the next day.
No, my lord, date fixed for the hearing.
No,
Other side, my lord, he is the union of.
oh, you are the junior.
Yes, my lord.
So let the date be fixed.
Yes.
Lordship, as you desire.
Who is leading you in this matter?
Mrs. Chandri.
Okay. Yes. So this application can do for?
And for the stay application.
Learned advocates for the parties are present. As this appeal is ready for hearing and the paper books filed, let this matter appear for hearing on.
As soon as my lord, my humble respectful submission, date be fixed is early.
Yes, দেখুন 18/8/2026 at 2 p.m.
Lord, 43, your lordship would be kind enough to extend the time to deposit the check.
Yes. 43, record an order. Learned advocate for the appellant is present. As the period fixed to deposit the check has expired, the time to deposit the check stands extended till 6/8/2026.
Extremely obliged, my lord.
Well, in this
Yes,
matter,
44.
I am appearing on behalf of the respondents claimants. I am submitting the copy of the paper. My lord, this is on the point of quantum, my lord. Next Saturday, my lord, your lordship, I have already requested Mr.
আমি স্যাটারডে আমি আসবোই না, আমি এত মামলা ফিক্স হয়ে গেছে আমি
That is the best remedy.
But so many matters,
Otherwise, request will come. Hey, this is a 26 matter. Why? What is so much urgency?
This is filed in the year, my lord. This is FMA 26.
Very well. So many old matters are pending.
And
It's
my
so
lord,
much.
stay is there, my lord. That is why, my lord, they are not getting.
So you know, in cases you see where quantum is challenged and the appeal cannot be taken up within a short period, in those cases, the prayer for withdrawal of some sums can be considered.
I have not yet made now the practice.
আমি বলতে না
Otherwise,
মিলট your lordship will fix it up in the last week of this month, Milord.
Last week of this, tomorrow is the 31st.
I'm Milord. Last week of August, Milord, or third week of August, I'll try to dispose it of.
Acha, record করুন তো, learned advocates for the parties are present. As the matter is ready for hearing and the paper books filed, let this matter appear for hearing. দেখুন 18 বা কবে ইয়ে করা হয়েছে? হ্যাঁ? কত 19? 19/8/2026 at 3 p.m.
Obliged to your lordship, Milord.
My lord, item number 30.
Item 13.
46 আছে।
Yes, call the passover items.
46 is there.
My lord, 46 number.
Just wait, just wait. Passover matter. Yes,
My lord,
46.
I am for the appellant. My lord, let the LCR be called for in this case, and with the help of special messenger court,
Yes,
we will prepare.
learned advocates for the parties are present. Let the trial court records be called for by special messenger cost to be deposited by the appellant within 2 weeks. The paper books be prepared on arrival of the trial court records. Liberty to mention after 5 weeks.
Yes. My lord, this appeal was disposed of.
This appeal was
46 है affidavit.
yes.
হ্যাঁ কেন আছে আছে কেন আছে
My lord, the paragraph. I have to
This is the Lok Adalat's award.
It would be Lokki LAKSHI and Shil SIL instead of SIL, it should be
And why
SIJ.
commercial? These are all okay.
Yeah. And my lord, the address also changed, my lord. The residing at Maheshpur Post Office, Mukundapur, and my lord, it should be, my lord, residing at Maheshpur, Talatala, slightly changed, Mukundapur. And my lord, 2 is Master Ayush. My lord, now he has become major. My lord, the your lordship kindly see the Aadhaar card at page 12. Lokhi Shil, I have annexed. And page 13 is the Malar Akashi.
Yes, record and order. Learned advocates for the parties are present. Although the appeal is disposed, but the appellants, with the appellants,
I'm for the appellant.
have filed this application for rectification of the name and address of the claimant appellant, Timothy Lokshmi Shil, as well as to record the majority of the appellant, Akash Shil. It is the contention of the appellants that the name of Timothy Lokshmi Shil be recorded as Timothy Lakshmi SHIL.
And also Akash.
And the husband's name be recorded as wife of late Nepal SHIL top and residing at Taltola, Malda, Mogdampur within bracket P, Mogdampur MAK GM Square, English Bazaar, Malda, West Bengal, pin 732103. Stop.
And also Malar appellant number 2, Akash.
Appellant number 2 has attained majority as reflected in
Also Malar
Aadhaar card filed in this application. Let thus the majority of appellant number 2, Akash Shil, be also recorded.
also the amendment also Master Akash. It is as Akash Shil.
And the Akash Shil's name be also rectified and corrected as Akash SHIL.
Yes.
The amendments be carried out within 2 weeks.
And Lakshmi Ananta ঠিক করে দিচ্ছে।
Grateful, my lord.
I'm grateful.
I'm for the respondent. Sima, kindly pass it over. In the meantime, I can go through the
Oh, I keep it on some other day.
At least I can go through the.
That you
See,
go through, let me fix it on some other day. Learned advocate for the respondent is present. As none appears for the appellant, the matter stands adjourned to. দেখুন 17-18 কবে আছে? হ্যাঁ? নাও আসতে পারি আমি। থার্সডে কবে দেওয়া যাবে? 6 তারিখ।
CPM
Lord, item 1 and 2 and 3 are not taken.
No, I am fixing a date.
এটা শেষ করে না।
দেখুন কবে আছে, তা পরের উইকে দেখুন তাহলে 6 তারিখে না হোক। হ্যাঁ, 10/8/2026 10th of August 2026 at 12 p.m.
এখনই করো, এখনই। রেকর্ডটা দিন 2 and 3 রেকর্ডটা দিন এলসি এর।
Yes, 2 and 3. Item 8.
Will not take.
Acha, item 8. Acha, item 8, let this matter stand adjourned till.
No, Lordship, kindly, all parties are here.
Item 8.
Item 8, yes.
Wait, just now. it
Okay,
can-
instead of 2 p.m. you want it to be taken up
Lordship,
now.
Lordship.
So let me see, let me take up other matters and thereafter I shall call this.
No, the other
2 and 3.
2 and 3 for the all parties are here. So Lordship, you can release Mr. Singh for the reason he said kindly taken up earlier after.
And
After this matter.
there.
ঠিক আছে, ঠিক আছে।
2 and 3 এই যে আমরা হ্যাঁ তার আগে 8টা নিতে বলছিলাম।
ছেড়ে দাও, ছেড়ে দাও, ছেড়ে দাও।
8 will take what, less time?
No, Lordship, kindly take it.
We were submitting that 8 may be taken up.
আচ্ছা, জায়গা 8টা কল করে দিন, item 8টাকে কল করুন।
Grateful, my lord.
ছিল না, তাই আমি তো চলে যাবো এখন। না, ওটা কোনো অর্ডার হয়নি, কোনো অর্ডার হয়নি। ওরা ছিল না তো, এই তো কাগজ বেরোনে।
Lordship, in this case, Mrs. Mukherjee prefer an appeal against the judgment and award passed by the learned tribe.
Very short point, my lord. Only,
What is the ground of challenge?
my lord, 1/5 has been deducted. 1/5 deduction has been taken for the number of dependents. It will be 1/4. And my lord, in the ordering portion of the judgment, pay and recover has not been taken. Although in the body of the judgment, it has been কত 128
I do not find any reason to
না।
adopt the principal pay and recover.
তারা
ঠিক আছে। Last paragraph.
So ground of challenge is instead with regard to personal deduction, it should be
Number
1/4.
of 6 number of claimants, so it is 1/4.
1/4.
1/4 instead of 1/5 as applied by the learned tribunal in the ultimate judgment. This is the,
And any other ground for challenging the quantum?
And,
that is the only issue of the quantum.
That is the only ground. And
and my
interest.
pay and recover, my lord.
Okay, let me see the order, impugn order.
Yes, Lord. So kindly come to page 128.
এই দেখো এখানে দেখো।
Observe, if the driver of the vehicle does not possess, he gets a war. Can be pay and victim recover the same.
এটা কি এখানটা কি?
May recover as per produce amount of compensation. Lord, you kindly turn to page 129 as per the submission of Mrs. Mukherjee, third paragraph. That is, I believe that is his basic ground. Page 129, third paragraph. Lord, you got it? The insurer may recover as per proper
Procedure.
the amount of compensation paid to the claimant.
Anyway, 128, I'm reading 128.
And 129 also.
128, the trial court has observed with regard to the Sharan Singh case.
Yes.
Yes.
Then let's kindly come to the page 128.
129.
আমি তো বলছিলাম বলতে দেন। Page 128 last paragraph. In the aforesaid circumstance, as such, I do not find a reason as to why the principle of pay and recover cannot be adopted in such situation in the such and such. Thereafter, while relying upon the previous decision and such, thereafter, Lordship had been pleased to observe that if the driver of a vehicle does not possess any valid driving license, the principle of pay and recover can be ordered to direct the insurer pay to the victim and recover to the same from the owner of the offending vehicle. In view of the unqualified recognitions and unconditional acceptability of the principle of pay and recover laid down in the aforesaid 2 judgment of the Honorable Supreme Court, the decision to the contrary as relied upon by the contested insurance company as this aspect of this case in this written notes of argument dated 13/2024 cannot be applied to the facts and circumstances of the case. The insurer may recover as per proper procedure the amount of compensation paid to the claimants for the owner of the insured vehicle being driven by the said Nobinur. So on this juncture, ultimately that was not reflected in the ordering portion. I believe that is the main grievance of the insurance company as appearing Mrs. Mukherjee.
So the pay and recovery is granted to you.
But in the ordering portion, it is not there, my lord. There were 2 vehicles involved, my lord. And no, the vehicle which was driven by driver Nobinur, that has that for that vehicle, for that insurance company, pay and recover has to be granted, my lord. বস হয়ে গেছে আর কিছু বলারই নেই
Opposite party Sheikh Nobinur.
Lordship.
And the insured vehicle was?
Both the national insurance.
No, insured vehicle number.
No, Nobinur is
Number.
the driver, Lordship.
আরে নাম্বারটা চাইছি
That
কি
the
জানি,
vehicle which he
নবীনও
was
কোন
driving.
গাড়িটা চালাচ্ছিল
আচ্ছা,
এটাই তো মুশকিল দাঁড়া
May I just, this, learned tribunal, has made the vehicle number. Lordship will kindly rule out the number, WB 19E. WB 19E 9347.
Please, page?
Page 3, Lordship, kindly come to page 3.
Page 3.
Page 3 of the paper book.
Page 3 of the decision.
Page 3 of the paper book. Column number 17.
Column 20.
17.
17, yes. Okay, WB 19E.
Yes, WB 19E 9347.
Which was driven, okay. The vehicle owner of which is?
Vehicle owner name, vehicle.
Adem Ali or Shamol?
Shamol De.
Shamol De.
It was jointly. It was jointly owned by Khadim and
Khadim and
Shamol.
Khadim, Ali Gain and Shamuldi.
And Monirul Koyal is the owner of another vehicle.
25F 3048.
So the dispute is with regard to the driving license of the driver of vehicle number WB 25F 3048. Against whom the compensation was awarded?
No, compensation has been awarded, WB 19.
Okay, 19E 9347.
9347.
Which is jointly owned by these 2 persons,
Khadim and Shamol.
Anyway, give me a calculation. If you deduct 1/4, how much it comes?
Kindly,
We
I
will
will with them in them.
Yes, record an order.
I'm grateful, my lord.
Learned advocates for the parties are present. Learned advocate. Appellant.
পরে মামলাটা আমার
Before this court. was an opposite party in a case under section 166 of the Motor Vehicles Act 1988 and is aggrieved by the judgment and award dated 24th February 2025 passed by learned Additional District Judge, Supreme Court, Alipur, South 24 Parganas, MSC case number 117 of 2017. Stop. The case of the claimants before the learned trial court may be summed up thus. On 19/9/2017, at about 8:40 hours, the drivers of the offending vehicle bearing registration number W capital B dash 19 capital E 9347 and W B 25F dash 3048 drove the same along Kolkata Basanti Road in a rash and negligent manner, endangering the human life and safety to others. And when it reached at the bus stop of half kilometer east from KLCPS, victim got down from the bus number WB 25F 3048 and all on a sudden the vehicle number WB 19 capital E dash 9347 came abruptly and dashed the victim in a dangerous manner. Stop. State bus tried to overtake the stationary bus in a dangerous manner. Stop. Due to this accident, the victim received severe injuries on his person and immediately removed to CNM College and Hospital, where he was declared dead. Stop. The accident was caused due to rash and negligent driving of the driver of both the vehicles. Stop. Due to premature death of the victim, the applicants are facing difficulties on the financial side, as the victim was the only earning member of the family. Pursuant to the filing of the case, notice was issued upon the opposite parties. Opposite parties. How many insurance companies are there?
Two insurance.
National Insurance Company and
National
both sub-same.
That is why, my lord, there is no inter-se dispute between those two.
The opposite party, National Insurance Company Limited, being the insurer of vehicle number WB 19E9347 and WB 25F3048, appeared and contested the case. Stop. However, the owners of the vehicle of being WB 19E9347, however, the owner of the said vehicles did not appear to contest the case. Stop. Issues were framed and evidence was adduced. Learned trial judge, upon considering the evidence adduced and upon hearing the learned advocates, was pleased to allow the claim case by observing and directing as follows. Taken together. Page 130, hold করে দিচ্ছি। এখান থেকে The appellant National Insurance Company Limited, being aggrieved by the judgment and award passed by the learned trial court, has come up with the instant appeal. Stop. The ground of challenge in the instant appeal is that the learned trial court considered the personal deduction as 1/5, which ought to have been 1/4, considering the number of the dependents. Stop. Another ground of challenge is that the learned trial judge, although came to a findings that the vehicle, that the owner of vehicle, sorry, the driver of the vehicle
Item number?
of the driver of the vehicle being number WB, okay, WB 25F3048. That was driven by this Navinu. WB 25F3048.
Name 19E.
No, when you say 19E.
19E 9347.
WB 19E 9347 was driven by Sheikh Navinu, but he was not holding driving license. Stop. But in the ordering portion, the learned trial judge did not grant any liberty to recover the same from the vehicle owner of WB 19E 9347. Stop. Learned advocates for the claimant respondent does not dispute the submission of learned advocate for the appellant. Stop. With regard to the personal deduction as submitted by the learned advocate for the appellant, this court is of the view that such submission has some substance, and considering the number, some has some substance. Thus, considering the number of applicants, although they have a right to claim compensation, but all cannot be treated to be the dependents of the victim. Stop. Thus, 1/4 compensation should be 1/4 on account of personal deduction should have been considered by the learned trial judge. In the event monthly deduction of 1/4 is considered, the monthly income taken as rupees 16,000, the future prospect being added, for 40% future prospect being added, the net monthly income comes to rupees 22,400. Personal expenses of 1/4 being deducted, the monthly income comes to rupees 16,800. I think in this case, future prospect is
Was
taken.
given.
Okay. The annual dependency loss comes to rupees 2,01,600. The multiplier of 15 being applied is rupees 30,24,000. Stop. Further, the claimants are entitled to rupees 77,000. Thus, 31,01,000 is the compensation which the claimants are entitled to from the appellant insurance company. Yes, Mr. Have you challenged the quantum of compensation? Then I can reduce this to 31 lakh. 31 lakh 1,000.
My
I
lord,
can reduce it.
My lord, my lord.
She has challenged the quantum.
Okay.
I have challenged the
However, quantum of compensation is also, as quantum of compensation is also challenged, this court is of the view that compensation of 31 lakh is just and reasonable. Hence, this appeal, just a minute. Now, with regard to the right of recovery, it is necessary to consider certain judicial pronouncement in this regard. In the case of Liraza Bibi versus National Insurance Company Limited in FMA 1003 of 2025, it was observed as follows. The blank hai. Thus, upon considering the judicial decision, the appellant insurance company has a right of recovery upon compliance of necessary formalities by conducting necessary inquiry and giving the vehicle owners an opportunity of being heard. Stop. Hence, this appeal, FMA 110 of 2025 stands disposed. The judgment and award dated 24th February 2025 passed by learned Additional District Judge, 16th Court, Alipur South 24 Parganas, in MSC case number 117 of 2017, stands modified to the extent that the claimant respondents are entitled to compensation of rupees 31 lakh from the appellant insurance company, along with interest at the rate of 6% per annum from the date of filing,
November 2017.
from the date of filing claim case till today. Stop. The appellant insurance company
Already deposited.
shall deposit rupees 31 lakh along with interest at the rate of 6% within 8 weeks from before the 6% before the Registrar General High Court, Calcutta, within 8 weeks from the date of communication of this order. Stop. In the event compensation awarded by learned trial court is already deposited, no further deposit be made. The claimant's respondents will be entitled to withdraw the compensation as awarded upon compliance of necessary formalities.
Equal share.
Necessary compensation in equal shares upon compliance of necessary formalities. The balance amount, if any, shall be returned to the appellant insurance company. Stop. The appellant insurance company will be entitled to recover the compensation amount in accordance with law by causing necessary inquiry and giving the vehicle owners an opportunity of being heard and following the procedure as laid down in the case of National Insurance Company Limited versus Lira Zabibi.
I'm grateful, my lord.
Trial court can send down at cost.
The trial court records be sent back at the special messenger cost to be filed by the respondents' claimants within 2 weeks.
We're extremely grateful for accommodating us, my lord.
My lord.
Thank you.
You're upright, my lord. Done. Oh, आपने लिखे.
In this case, I am for the appellant.
What?
Wow. Very good.
Yeah. My lord,
Yes, item 2.
my lord, very short. My lord, this is an death case under section 166 of the Motor Vehicles Act. My lord, in this case, the deceased victim
Yes.
was a passenger of a Tata Magic car.
Yes.
And when the said Tata Magic car was proceeding on the road, a truck dashed the said Tata Magic car. And therefore, the victim sustained injuries and died in the hospital. My lord, in this case, 2 insurance companies are there.
One is National Insurance.
Another is Oriental Insurance Company.
I'm for the road.
Oriental Insurance Company satisfied the our data what I have received.
বলছি আমি, তুমি চুপ কর না।
না ওইটা আমি রিসিভ করেছি বলে দিলাম স্যার।
আমি বলছি।
Yes, we have already.
There is a counter objection also.
No.
Yes, Lordship. I have cross objection is there on the question of quantum, but 50-50 hour passed, 50% I have received.
As per the FIR,
Yes.
the lorry was solely responsible for the
Dashing from behind or head-on collision?
head-on collision. As per the FIR, truck was jute loaded truck.
My lord, FIR was lodged, and as per FIR, the said truck was solely responsible for the accident. Truck insured with the Oriental Insurance Company Limited. I am the insurer of Tata Magic car. As per charge sheet, my lord, truck
Drivers are involved.
driver of the truck,
No, charge sheet submitted against whom? Only truck,
only truck,
not this vehicle driver.
not this vehicle driver.
You are representing the truck insurance.
No, I am representing the car insurance.
Okay. Okay.
And as
Charge
per
sheet submitted against truck.
truck driver. My lord, eyewitness also stated in his deposition that truck solely responsible for the FIR, charge sheet, eyewitness statement. All are against the truck. But learned tribunal awarded compensation.
So charge sheet is not submitted against this truck, this
Tata
truck.
Magic car.
No charge sheet submitted.
No
against it.
charge sheet submitted. No eyewitness stated. No FIR against the Tata Magic car. But learned tribunal awarded 50-50 both the insurance company without any reason. This is my case, my lord, very shortly. My judgment is page 46 of the paper. 46.
I'm not liable for তারপরে যে তাই আর কিছু বলছে না
ওকে দিয়ে দিচ্ছি বাবা, আমার হয়ে গেছে বলো।
বাবা আমার ঘরে চাকরি সে কিছু বলছে না আমার ঘরে উনি নিয়ে যান
আমার কেন এটা
Yes, 46.
My lord, 46 is the judgment. Relevant fruits are, my lord, decision with reason, page 48.
ওই তো পেন্সিল লেখা আমার এই পেন্সিল লেখা আমার
My lord, page 49 is the relevant.
Yes. So what is the findings regarding negligence?
No findings, sir.
নেক্সটটা বলে দিই
হ্যাঁ ফাইন
কোথায় finding? আছে findings is আছে।
আছে আছে আই উইটনেস বলেছে
Yes.
আই উইটনেস বলেছে জাজমেন্টে পাবে না তুমি সাক্ষীতে যাও
কিছু নেই, কিছু নেই।
Yes.
My lord, when I show your lordships the FIR, copy of FIR, page 28. No, 24, my lord, your lordship, page 24.
Yes.
লাস্ট পোর্শন উক্ত ট্রাকের ট্রাক চালকের গাফিলতিতে এই দুর্ঘটনা ঘটেছে এবং এটা আপনার জন্য সামনের জন্য উক্ত অজ্ঞাত চালক এবং দাঁড়া আর কি বলবো ট্যাক্সিটা কোথায় ট্যাক্সিটা কোথায়
এগুলো আমার পড়া আছে তো এরকম পেপার পড়ে নেওয়ার মতো
তেত্রিশ
33
মানে চার্জশিট পেজ 33
Here is here. Will you kindly
সার্টিফাইড কপি আবার তুই তো দিয়েছিস
legible copies.
Yes, Lordship. For the reason, kindly consider.
মানে পেজ 37 লাস্ট
Let me see the trial court records if the charge sheet is there.
Yes. Lordship, kindly see they are legible. Kindly see last paragraph.
39,
31, 37.
37
35, 36.
তুই আমাকে কি হেল্প করছিস?
Future perspective দিবি
বাবা সব দেবো, তুমি ওনাকে দেওয়া করো।
আরে ওনার 50% তো 50% হয়ে আছে, তুই কি করে লাইবিলিটি অ্যাভয়েড করবি? অলরেডি আই আর স্যাটিসফাইড এই দুটো পেপার নাকি
ও বলছে যে পুরোটা আমার ঘাড়ে চাপিয়ে দেবে।
সেটা কোনো কথা
তো তাই বলছে তো। তুমি কি বলছো? কি বলছো তুমি? তুমি অনেক কিছু হয় না এরকম হলে কি হবে?
আমার কোম্পানি আমার
সে তো আমারও কোম্পানি, তাতে কি হবে না?
না। সেটা স্যার বলেন।
এই ঘাড়ে চাপালে ওই রেন্টাল ধরে আমার
বললো আপনার এগেনস্টে চাপিয়ে দিয়েছেন, আপনাকে আর প্যানেলে রাখবো না। বলে দাও,
এটা বলবে না বলবো এক মামলা দেবো না
মামলা দেবো। আমার এখনো যায় হাজারখানা মামলা আছে, সেগুলো আগে করি। আরে না, আমাকে দিয়ে তো একটু
কিন্তু রাস্তাঘাটটা আমি পড়বো লাস্ট করে এইখানে তো তোমার পার্টি হয়ে আছে ডকুমেন্টারি প্রুফ
কি হবে কেন? 60 তো হতে পারে, আপনি কম হতে বেশি 40 বছর কেন?
হবে না আমার কোনো নেগলিজেন্স নেই কেন যাচ্ছি বলবো তাই ওই লাইনে চুপ করে থাক বাড়িয়ে নিয়ে চলে
হেড অন কলিশন তো, ওটা বলো তুমি।
How many persons died in that accident?
1%.
Only 1%. 10, 12 persons were injured.
Yes.
Yes, injured.
As a result, instantaneous death of 7 numbers. It is stated in the charge sheet. It is stated 7 numbers.
Yes, Lordship.
How many persons were accommodated in the Tata Sumo vehicle?
My lord, your lordship see the evidence of eyewitness.
Okay, just a minute.
আসো আসো, আমি চুপ করে আছি, ওই জন্য এভিডেন্স অফ আই উইটনেস আসো। বার করো বার করো আই উইটনেসটা বার করো না হুম I cannot say. ওটা ছাড়ো
passenger in the said vehicle.
হ্যাঁ দাঁড়াও I was sitting on the back side of the vehicle. As
Nine
such, the
persons
road from
expired.
I saw the after the accident. It is a fact that I was on the back seat. It is what was not possible to me see the movement of the said truck. তো আমি ঘুমাচ্ছিলাম তো আমি কি করে আই উইটনেস হলাম আফটার গেটিং ডাউন অত কি কি ক্রিমিনাল ট্রায়াল না এত চুপ কর
Yes, let us see the evidence.
My lord, page 18 of the paper book.
Page 18.
18. Eyewitness.
I have not
My lord,
been
part my lord, PW1,
when the alleged accident take
the wife of the victim, page 16.
এটাই আমার পয়েন্ট তোমার নয় ইউ আর নট তোমার কিছু আসে যায় না এ দিল এ টাকা দিল না বি টাকা দিল এটা
Yes, this is the witness.
Witness.
Yes.
PW1
The eyewitness
My lord,
page 20.
PW1
Page 20.
Page 20 is cross-examination.
Yes. Co-passenger in this Tata vehicle.
Yes. It was the passenger carrier vehicle. It is not there the gratuitous passenger. They are the passenger carrier vehicle, so their presence in the car is authorized, legally authorized.
No, how many passengers this car was carrying? 16 to 17.
16, 17.
It's a commercial vehicle.
No, yes, commercial.
Commercial vehicle.
Take car, my lord.
একটা কিছু জানাও প্রচন্ড গরম লাগছে তো
Aye.
কি গরম লাগছে আমার হাঁসফাঁস করছি প্রাণটা আমার
Aye, babu.
আরে ও দাদা একটু ফ্যানটা চালাও না ভীষণ গরম লাগছে
Yes, that is there. PW2.
Yes. Eyewitness.
Yes.
Therefore, my submission is, my lord, the Tata Magic, driver of Tata Magic car was not at all liable.
Yes.
But Rana Tribunal erroneously awarded 50% amount against me. And my lord, my learned friend Clement, my lord, filed a cross objection for enhancement on some ground, my lord, that is
Let me hear Mrs. Mukherjee. Yes.
My lord, please come to page 20 of the paper book.
Yes.
Cross-examination by Oriental Insurance Company. My lord, I've already seen it, but I'm repeating it again. Tata Magic is a light motor vehicle, and it is not a fact that Tata Magic is goods carrying vehicles. Witness volunteers, it is passenger carrying vehicle. The road between Malda and Balurghat is two-lane road. There is no separate driver cabin in the Tata Magic vehicle. I was sitting on the back side of the vehicle. As such, the road from backside was not clearly visible. I saw the offending truck after getting down from the vehicle. It is a fact that I was on the back seat of the vehicle. It was not possible for me to see the movement of the said truck. So he did not see the movement of the said truck. So that's why the learned tribunal was absolutely correct in the liability of the two vehicles. My lord, I rely upon Khenei.
Very good.
পরে দিলেও হবে।
Yes.
Para 14 of the judgment.
Yes.
My lord, I've got it. There is a difference between contributory and composite negligence. In the case of contributory negligence, a person who was himself contributed to the extent cannot claim compensation for the injuries sustained by him in the accident to the extent of his own negligence. Whereas in the case of composite negligence, a person who has suffered has not contributed to the accident but outcome of combination of negligence of two or more other persons. This court in Teo Anthony versus Karavaranan has held that in case of contributory negligence, injured did not establish the extent of responsibility of each wrongdoer separately, nor is it necessary for the court to determine the extent of liability of each wrongdoer separately. It is only in the case of contributory negligence that the injured himself has contributed by his negligence in the accident. Extent of his negligence is required to be determined as damages recovered by him in respect of injuries to be reduced in proportion of his contributory negligence. The relevant portion is extracted under, my lord. Here it is composite negligence, my lord. Here it is composite negligence, where head-on collision means the driver who was driving the maxi car with so many passengers, he has to be very alert while driving that car also. So that's why the learned tribunal has apportioned the award between the two insurance companies of the offending vehicles, of the vehicles which were involved in the accident. I have already satisfied the whole I've already deposited the amount which was given towards me, and I will not be saddled with any other liability whatsoever.
Yes.
My learned senior friend client may be saddled with the liability, which for
So according to you, the learned trial court has rightly apportioned the liability.
my lord, because otherwise these drivers of the maxi cars cannot be. We told my lord, they are driving a maxi car with passengers. They should also be careful while driving, my lord.
Yes, Mr. Mitru.
Lordship, with regard to the submission being a claim in lordship, brother, I have no submission. But the question of law as my
Quantum, you are challenging the quantum.
quantum, the
হ্যাঁ, ওখানে
quantum
বল।
only the
তুমি
issue.
ওসব আসলেই না। চুপ করে থাকো।
Quantum issues, Loretta, I have filed cross objection on that issue. Lordship, the learned tribunal did not consider the
Your
future-
cross objection.
Yes, page 61, 25% future prospect and the loss of general damages, loss of consortium, whatever
No,
lordship.
no, future prospect not at all taken into consideration.
No, no, lordship.
কবে হয়েছে জানো?
If you kindly turn to page 50 or the trial court record. So the learned tribunal monthly income 12,000, that I am not challenging because of the income tax pay in the income return has been filed. Exhibit 16, that is within the record. So that I am not challenging. Only this part, the future prospect in respect of the age of the victim is a 41 years, is the business of lordship Hari business.
So future prospect should be how much according to you?
25%.
25%. And general damages, how much was awarded?
Uh,
70,000.
Yes.
General damages, how much was awarded?
That is 5,000, 9,500 is in view of the old act. So in view of the Punashati, Sola Verma,
Anyway, 70,000.
whatever lordship, no, real lordship
70,000 and the future prospect of
25%.
25%.
Lordship, seven-
Anyway, make your calculations with regard to quantum. Thereafter, I am deciding whether to apportion or to fix it upon a particular owner.
Lordship kindly see.
We are doing the calculation.
So,
Calculation
so lordship is perfectly said that 77,000. 10% every 3 years.
Okay, it hardly matters 70,000, 77,000. The main thing is future prospect.
No, future will be 25%. General damages.
General damage is either 70 or 77, whatever it is.
Either
27 lordship kindly see this 2000 case was
Anyway, you calculate.
very well, lordship. 2011
ক্যালকুলেট করো, এত কথা বলছো কেন?
মানে I have deposited the entire amount before the honorable.
কত হচ্ছে না?
একটা কাগজ দিন।
Now the question is, you see, in composite negligence, is there any scope to reduce this thing, this liability, is that without 50-50 as 75-25? There is no scope.
Where is composite negligence in this case, my lord? I didn't not see, my lord. My lord, in the canine case, my lord, last paragraph of the canine case, your lordship consider.
Para 7. Yes, no. This was decided in this Tio Antony.
Para 18.
কোথায় আছে? কোনটা পড়ছেন? কোন প্যারা?
No, the principles of composite negligence. What are the principles?
Para 18, my lord.
Para 18. No, that's a different issue.
That is a
Parity
Para
Kala
14.
Valtarma has been discussed.
para 14 is deals with composite.
My lord, what emerged from the
Para
aforesaid
18
discussion is as follows.
Yeah.
1, 2, 3.
In case of, no, whether you see, what should be done in case of composite negligence, that is let down.
Yes.
But whether, what constitutes composite negligence, that depends upon the facts of each case.
Yes. Yes.
Now, another question is, you see, suppose court holds that composite negligence is 50-50. Is there any scope to change the proportion? That is the thing.
That logic has given in this judgment.
Jump
Exactly
upon
that logic given by the
Which-
Supreme Court in this judgment.
Yes, this Khemai.
Can I?
Yes, which paragraph?
Plus you answer. Yes, Lordship. Paragraph 7. Paragraph 14, subparagraph 7. Therefore, Lordship found it.
Yes.
Paragraph 7, 6, composite. Then
Yes.
7. Therefore, two vehicles are involved in the accident. So, question of involvement, Supreme Court quoted this word, involvement.
Yes.
Involved in the accident. And one of the drivers claims compensation from the other driver, alleging negligence. And other driver denies negligence or claims that the injured claims that the injured claimant himself was negligent. Then it becomes necessary to consider whether injured claimant was negligent, and if so, whether he was solely or partly responsible for the accident, and the extent of this responsibility, that is the contributed negligence. This is not our case. Therefore, whether injured himself partly liable and the principle of composite negligence will not apply, nor they can automatically infer that the negligence was 50-50 as has been assumed in this case. So maybe it's 40%, maybe 20%. Who will? So speed has to be checked up, driver mood has to be checked up, the vehicle has to be checked up. So there is some evidence is required for it.
Six
Yeah.
also, six also read composite negligence.
Yes,
refers
composite
to the-
negligence means this is a case when lawsuit is deciding there is a composite negligence. This is not a contributing negligence.
So it is not a case where you see this this truck driver, nobody died in the truck. It is only this
passenger died.
How he was driving that car.
Yes,
That's what the
that has to be,
tribunal
so
has
to that
rightly
extent has to be
asserted.
there because
Okay.
of
Which page the tribunal has discussed this matter? The involvement of both the vehicles?
Not discussed. Not discussed.
Lordship, kindly come to page 48.
Yes.
PW1, the evidence of the PW1 summarized by the learned tribunal.
Yes.
As when the business of purpose of police started over the state accident number such as the accident occurred due to high speed of the offending vehicle number such and such a truck for rash and negligent driving by the driver of the offending vehicle, and police seized the offending vehicle and filed the charge sheet above mentioned case as against the driver of the offending truck, and the said offending vehicle was insured by the Oriental Insurance Company. And then eyewitness. Then Lordship kindly see considering the above, and then Lordship kindly see the fourth paragraph of the page 49. Considering the above facts and some of the documented evidence, I am inclined to add such as that this is longer proceeding such that purpose of the business one direction coming opposite direction towards Malda and said offending truck was proceeding at a high and excessive speed. Jute loaded and all on a sudden near place of such and such on National Highway 34. The driver of the said truck lost his control and collided with the said Tata Magic, a result of which Shankar Bashai received severe multiple injury and admitted in Malda hospital and died on the same day. So lordship is the composite negligence.
আরে না এখানে লেখা আছে তুমি পড়ো PW1 অরুণা বসাক highlight in the same page 49.
Yes.
Same PW1 Oruna Boshak has stated in her examination in chief that the Tata Magic car bearing number such and such was duly insured by the National Insurance Company is also liable to pay the compensation.
So he may say, but he is not decide the issue.
Oh, she may say because she is not the witness.
Yes, this is not good. How will he say with that vehicle he is the only claimant? That he may say, but that can be taken into consideration.
Eyewitness also have not.
Okay, the accident occurred due to high speed of offending vehicle, truck.
Both the vehicles, driver liable.
Anyway, she is not the eyewitness.
She is not the eyewitness. So this is not the issue.
So whether how far PW2 is to be relied upon?
Lordship.
PW2 said that he could not see the accident.
No.
Yes. He said.
Okay, he could not see, but he
he could not see, no, he could not closely observe the moment of accident. But he has not knowledge the accident will be happen. So he was on the passenger. So after the accident, whatever is seen, that is described.
Head-on collision is admitted. Okay, charge sheet submitted only against the truck driver.
Yes,
Oh, this Tata Sumo driver survived or he died as per the charge sheet?
Yes.
That is the question. About 7 persons died in that sumo vehicle.
কি ড্রাইভার মারা গেছে?
That is not clear in the FIR. From complaint.
No, but 7 persons died.
7% died.
My lord, in the FIR, page 24, বিপরীত মুখী.
Yes, yes, opposite
No,
direction.
opposite
Opposite
direction.
direction, head-on collision. That's why the learned tribunal has aptly considered it as 50-50. Because he was
Really,
taking
when this-
so many passengers, this Tata Magic car. He should have been careful.
Just as you see, the contributory negligence, you see, has to depend upon the facts of each case.
Yes, Lordship, in the charge sheet.
Only or partly.
Lordship, kindly see the negligent driver of such and such. As a result, the train of seven number of passengers of Tata Magic, passenger including driver of the driver, besides grievous hurt and Lordship, kindly see the case.
Or driver was grievous hurt.
Yes, he was hurt, and he was a passenger received the reliable aid. Yes, sir. So that would, up to that is there.
Okay, charge sheet not submitted against the
Not remaining Mr. Pahari.
he was grievously hurt.
That is the including its driver of besides grievous hurt of 10 to 12 passengers and people of their reliable aid. Yes, accident due to the rash and negligent driving of the truck driver. That is the Mrs. Mukherjee's client.
Yes, take down. Give the calculation. Learned advocates for the parties are present. Hard learned advocates. The appellant, National Insurance Company Limited, was an opposite party in a case under section 166 of the Motor Vehicles Act 1988 and is aggrieved by the judgment and award dated 7th November 2013 passed by learned Additional District Judge Kalna, Purbo Bardhaman, MAC case number 13 of 2011. The case of the claimants in the claimants before the learned trial court may be summed up thus. On 5/9/2010 at about 5 a.m. while Konkur Bashak, since deceased, was proceeding towards Balurghat from Malda by a Tata Magic bearing registration number WB65 capital A stroke 0715 for the purpose of his business. At that time, one truck bearing registration number WB03 capital A stroke 5629 coming from opposite direction towards Malda and proceeding at a very high speed and with jute loaded all on a sudden near the place of Kalna Digi on the National Highway number 34. The driver of the said truck lost its control and collided with the said Tata Magic. Stop. As a result of which, Thankur Boshak received serious multiple injuries on his person and he was admitted to Malda District Hospital under the jurisdiction of English Bazaar PS. And he died at the state hospital on the same day. Stop. The accident was the result of rash and negligent driving of the aforesaid truck by its driver. Pursuant filing of the claim case, notice was issued upon the opposite parties. Opposite party, the truck owner, the Tata Magic vehicle owner did not appear to contest the case. Stop. However, National Insurance Company Limited, being insurer of Tata Magic vehicle and Oriental Insurance Company Limited, being insurer of the truck, contested the case by filing written statements. Stop. Issues were framed and evidence was adduced. Stop. Learned trial judge, upon considering the evidence adduced and for hearing the learned advocates, was pleased to dispose the claim case by observing and directing as follows. Get out. Page 51. The appellant, National Insurance Company Limited, being aggrieved by the judgment and award passed by the learned trial court, has come up with the instant appeal. Stop. The respondent, Oriental Insurance Company Limited, has satisfied the award as directed by the learned trial court. Mr. Pahari, learned counsel for the appellant, National Insurance Company Limited, submits that although the truck is solely responsible for the accident, but the learned trial court erred in distributing the compensation to be paid by National Insurance Company Limited and Oriental Insurance Company Limited. Stop. Learned advocate further submits that the allegation in the FIR is against the truck driver, and in the charge sheet also the police authority submitted in the charge sheet also there is only mention about the truck driver. Stop. It is submitted that the Oriental Insurance Company Limited should bear the entire compensation. Stop. Mrs. Mukherjee, learned advocate for the Oriental Insurance Company Limited, submits that there is involvement of both the vehicles in the accident. Mrs. Mukherjee draws attention to the evidence of PW2 Jagannath Boshak and submits that in the cross-examination, the said witness stated that the offending truck, that he saw the offending truck after the accident, after getting down from the said vehicle. and that he was sitting at the back seat of the vehicle and it was not possible for him to see the movement of the said truck. It is submitted that on the basis of the statement of PW2, the entire truck driver should not be made liable. Mr. Rai, learned advocate for the claimants, who has filed an application for enhancement of the compensation, has filed an cross objection for enhancement of the compensation, submits that the learned trial judge or in not considering the issue of future prospect
of every 3 years interval.
It is further submitted that the general damages awarded is only rupees 9,500, which should be enhanced. It is also submitted that the total compensation awarded by the learned trial court should be enhanced due to the effort, should be enhanced. Upon considering the submissions, upon considering the submissions of the learned advocate for the parties and considering the materials on record, it appears that charge sheet was submitted against the driver of the truck. Further, in the FIR, the allegations was made against the truck driver. It also appears that 7 persons who were in the Tata Magic vehicle died and some suffered grievous injury, including the driver. Upon perusing the materials on record and considering the evidence of PW2, although the truck driver cannot be made solely liable for the accident, and the liability is to be borne by both the vehicle owners. However, both the vehicle owners are not equally liable, and the truck driver, the responsibility of the truck driver is more in the instant case. Stop. Now, with regard to the quantum of compensation, yes.
Yes, Lordship, almost ready.
দুটো শূন্য
3টে শূন্য আশ্চর্য
দিন এটা with regard to the quantum of compensation, it appears that as the future prospect is not awarded by the learned trial judge, and the total monthly income considered as 12,000 and the annual income as rupees 1,44,000 and 1/3 being deducted, the net annual income comes to rupees 96,000. Thus, yes, what is the future prospect?
25%.
Oh, right. As the victim was 41 years of age, the multiplier of 41 should be, multiplier of 14 should be applied. Thus, the net total dependency loss comes to rupees 13,44,000. Future prospect being added, the total dependency loss comes to rupees 16,80,000. The general damages being added, general damages of rupees 77,000 being added.
10% of every year, that is Punachari judgment.
I have a
10% of every year.
70,000 is okay.
No,
91.
70,000 will be okay, my lord.
Lordship, according to Punachari, 10% for every
Very
year.
well. General damages of rupees 70,000 being added, the total 70. the total compensation comes to rupees 17,50,000. Stop. However, in the view of this court, compensation of 17 lakh is just and reasonable. Now, with regard to the liability of compensation to be borne by the vehicle owners, considering the evidence and the acts of both the drivers, this court is of the view that compensation of rupees 10 lakh should be borne by the truck owner, which is insured with Oriental Insurance Company. Stop. And balance amount 7 lakh should be borne by the Tata Magic vehicle owner, which is insured with the National Insurance Company Limited. Stop. Hence, the appeal FMA 538 of 2023 stands disposed.
Granted interest.
Yes, yes. The judgment and award dated 7th November 2013, passed by learned Additional District Judge Kalna Purbo Bardhaman in MSC case number 13 of 2011, stands modified to the extent that the claimants, respondents are entitled to compensation of rupees 17 lakh from both the insurance companies. Stop. The Appellant National Insurance Company Limited shall deposit before the Registrar General High Court, Calcutta, rupees 7 lakh along with interest at the rate of 6% per annum from the date of filing of the claim case till today. Stop. The respondent Oriental Insurance Company Limited shall deposit 10 lakh along with interest at the rate of 6% per annum from the date of filing of the claim case till today.
10th May 2011. Because of they will deposit, that's what the date is required.
Just a minute. In the event the compensation awarded by the learned trial court is already deposited, the balance amount will be deposited by the insurance companies along with interest. The claimant respondents will be entitled to withdraw the compensation upon compliance of necessary formalities.
So one thing that the award satisfied, that a part can you consider?
We have already satisfied.
I've stated if already deposited or satisfied, the balance amount be deposited.
হ্যাঁ সেটা বলেছে
I've stated that if the compensation awarded by the trial court is deposited or satisfied, the balance amount be deposited.
হ্যাঁ ওটাই ঠিক আছে
I've made it clear.
May I one can allow me to see the trial court record? The court fee is already been deposited because of so kindly can record it where
the court fees, if not the court fees on the enhanced amount, if not paid, be paid before the learned trial court.
Will paid by that person. And if
I'm making before the trial court.
Because of record is before your loss.
No, I'll direct the trial court records be sent back at the special messenger post. The court fee and the court fees on the enhanced amount be paid before the learned trial court within 4 weeks. The trial court records be sent back at the special messenger cost to be deposited by the respondents claimants within 2 weeks.
Kindly make one sentence in equal share if 3 claimants are there.
That is there by the trial court. Whatever trial court has recorded, that the trial court will follow. The shares will be as per the proportion as directed by the learned trial court.
Actually, there is no specification.
No. Before the trial court, what is there?
And they are minor. On the occasion, they were minor. Although there is no specification for that. One line equals.
Okay, the proportion, the distribution of the compensation shall be in equal shares.
Fifth matter that is fixed. That's it. So 10th I will not be another matter also fixed on the 11 and 13.
I shall keep it on that day. Okay, let it appear. I shall. যাকে অর্ডারটা চেঞ্জ করে দেবেন 11 করে দেবেন তাহলে তো বলে দেবেন বলে এটা চেঞ্জ করিয়ে দেবেন
I'm for the claimant response.
এই অমিত তোরটা দিয়ে দেখো না আমার পরের মামলাতে
আপনার নাম তো অ্যাপিলের পিছনে পেয়ে যাবে
My lord, I'm for the respondent claimants, my lord.
yes
Yeah.
yes
my lord, let my learned friend start. I'll come.
it is your appeal
My
no his submission will be on the quantum what is your submission
lord,
or if you want I can take it up at 2 p.m go through the records and come yes 2 p.m
my lord, we can finish it.
My lord, it's a very small matter. The fact of the matter is, my lord, the tribunal, a bus was proceeding from Kolkata towards Asansol site. In front of that bus, there was a truck. The evidence suggests that the truck suddenly applied brakes and the bus collided with the truck from behind. Now, my lord, my learned friend is in her memorandum of appeal has taken a point that there is a issue of contributory negligence. The bus driver should have been more cautious.
bus ought to have been implemented
No,
this is the
my lord,
composite
I am
Dashed the truck from behind.
and the passenger suffered injury
no the claimant. The driver of the bus is the claimant in this case.
Your total contributory negligence, my lord, according to Kenney with the
okay bus dashed the truck
my lord from behind. Again, Kenney comes.
okay driver is the claimant here
Yes.
Yes.
the only question is whether there was any contributory
Yes.
negligence
Memo page 66.
that driver means driver's family
Driver's family. It's a death case.
yes
And the driver was driving the SBSTC bus, my lord. You know very well how these SBSTC buses are being driven on the high roads.
These are presumptions, my lord.
No
This cannot be.
presumptions.
What is the evidence?
We know how they drive. You also know,
But these are presumptions.
okay
How
ground
can our
of
knowledge
challenge
come
is
in?
contributory negligence
my lord. Ground of challenge is contributory negligence, and the award may be apportioned. The victim was responsible for the accident. Again, Kenney comes into.
Yes.
Not the paragraph 14 of Henning. Why not have got it? Paragraph 14, subpara 7.
Yes.
When two vehicles are involved in an accident and one of the drivers claims compensation from the other driver and alleging negligence, the other driver denies negligence or claims that the injured claims was negligent, then it becomes necessary to consider whether injured claimant was negligent, and if so, whether he was solely or partly responsible for the accident and the extent of his responsibility, and that is contributory negligence. My lord, I am driving my car and I am dashing a truck from behind. I have some percentage of contribution to the accident.
Yes. There are other decisions of contributory negligence.
Hene is the landmark judgment.
This is a composite negligence.
So, my lord, composite.
You know, contributory negligence is a different. Composite means two involvement of two vehicles.
Grateful.
Here you see there is no involvement of two vehicles. This person and the vehicle truck. So it should be the contributory negligence because this person was driving the vehicle.
Yes.
Had it been passengers, bus passengers, then yes, these two vehicles. Composite negligence.
Here, my lord, he is claiming for himself. Means
That is why contributory negligence, not composite negligence.
he is claiming for him. Actually, his family is claiming for the.
Yes, that is why contributory. In case of composite, any any vehicle can be implemented. Compensation can be obtained, and thereafter liberty can be granted to recover.
Yes, my lord. But here, because I have contributed to the negligence, I am.
There are other decisions with regard to contributory negligence. You come with this decision, Justice S.B. Sinha.
I'll
Yes, S.B. Sinha Supreme Court decision. There are other decisions. Please come on the next day.
My lord, I'll cite those decisions.
Oh, you have with you?
My lord. Let me. My lord, we don't even. My lord, we don't even need
any quantum are you challenging?
I have challenged the quantum by filing a cross objection.
Only you want this contributory negligence and apportionment. Yes.
Only that is. My lord, I have in my claim application in column number 23, the facts that I have narrated is that I was proceeding from Kolkata towards Asansol by driving that SBSTC bus. It belonged to the Belgoria department, Belgoria depot. Now, my lord, while proceeding towards Asansol, the truck, the offending vehicle, was proceeding in front of me. It applied a sudden brake, which did not give me the opportunity to stop my bus, which I was driving along with passengers. In order to prove that, my lord, I have adduced evidence who has confirmed that the truck in front of me applied sudden brake, because of which the bus could not be stopped. Now, apart from the independent witness, my lord, there's a FIR which is lodged by the conductor of that particular bus. He, just after the accident, lodged the FIR saying that the truck applied the brake suddenly, because of which the driver could not stop the vehicle. This, my lord, has been subsequently been corroborated by the independent witness. Apart from that, subsequently, my lord, a charge sheet has been filed where the driver of the offending vehicle, the truck, has been charge sheeted because of negligence. Most importantly, my lord, whether this point of contributory negligence was framed as an issue before the tribunal. They did not take up this point. My lord, kindly comes to page 60, page 60 of the paper book. Kindly see the issues which have been framed. 60. I'll come to the merits later on, my lord. Kindly see whether this appeal is maintainable in the first place or not. Kindly see, my lord, page 59 and 60. Issues. The first issue is the case maintainable in its present form and prayer? Second is, did the accident take place on 13/5/2013 on Durgapur Asansol Road between DVC Mode and Govindanagar opposite to Jasbir Singh Hotel due to rash and negligent driving on the part of the driver of the vehicle bearing number such and such, which is the truck? Third, did any person named Acholesh Maiti die due to the motor accident as claimed? Fourth, had the next page, my lord, had the driver of the vehicle valid and effective driving license at the time of the alleged accident? Was the vehicle in question covered by the insurance policy on the relevant date? Is the OP insurance company liable to pay compensation as claimed? If so, what and to what extent? Are the claimant's petitioner entitled to get compensation as claimed? To what other relief are the claimant's petitioners entitled? Where is the, my lord, the issue with regard to the contributory negligence? They did not take up this point before the tribunal. The tribunal has not ruled on the issue of contributory negligence. How can they take up this point in appeal? This ground of contributory negligence has for the first time appeared in the appeal. The issue has not been framed. This point was not argued. This evidence was not laid. Who, my lord, if I put this question to myself, who was the best person to adduce evidence whether the truck driver had applied sudden brake or not? The charge-sheeted person, which is the truck driver himself. They have not adduced evidence. There were several other passengers in the bus. They have not called even a single witness. I have proved my case.
One passenger or conductor adduced evidence?
Now, evidence adduced by an independent witness who was present in the hotel before which the accident took place.
Let us come to that.
And the charge sheet has been filed against the driver of the offending vehicle.
What is that in the eyewitness?
My lord, my lord.
Independent witness, my lord. Page 25.
Page 25.
Cross-examination, my lord. My lord, I have got it.
Yeah. Yes.
I am a businessman. I carry on business dealing in supply building materials. I have no trade license or other documents regarding my business. I have no document to establish that I am a businessman. I did not receive any summons from court to depose. So this is not an independent witness. Devobroto Maiti has asked me to depose in his case today.
Devobroto Maiti is the claimant.
Who is it?
Claimant's son.
Claimant's son.
At the time of accident, I was taking tea in a hotel, and as such, the owner of the hotel can say that I was present at the time of incident on the spot. The distance of Jasbinder Singh Hotel from the place of occurrence was 40 to 50 feet. The hotel is situated on the northern side of the highway. There is no other shop or stall between hotel and highway. I was taking tea on the table kept in open in front of the hotel. When I was taking tea was facing south. There was no bus stop at the PO. Several vehicles pass frequently through the highway. There is a divider on the highway about 3 feet wide and 1.5 to 2 feet in feet.
Several vehicles were flying towards Asansol.
1.5 to 2 feet
in height.
In height. Several vehicles were flying towards Asansol and were coming from Asansol. The bus was at a high speed, my lord, kindly see.
My lord, it's a highway.
When I
is the bus supposed to run slowly on a highway?
When I heard the sound of dashing of the bus with the truck, I reached the PO within 2 minutes, not a fact. I have not seen. This
Well,
is what the independent witness says, and also this independent witness was
Is
called by the
Is a charge sheeted witness. Charge sheet witness.
No, my lord, the question is
conductor
why,
is also the witness.
why should a truck run at, why should a bus ply at a low speed on a highway? It's a
Anyway, the
highway.
truck was not stationary.
No,
Truck was not stationary. No, কোথায় লেখা আছে? ট্রাকটা কিভাবে যাচ্ছে?
Truck stopped all at a sudden. It's not
Yes,
that truck
yes.
was stationary.
Yes.
FIR এ কি লেখা?
FIR.
পড়ার উপায় নেই।
হ্যাঁ, আমি পড়বো। May I read the FIR
Yes.
made by the conductor?
Conductor is the interested people.
How, my lord, how he is a witness? Interest. Conductor is not a
Complainant, charge sheeted
yes,
witness.
and they have not called him in witness box. আমি নিম্ন স্বাক্ষরকারী আপনাকে জানাইতেছি যে গতকাল 13/5/2013 আমি এসবিএসটিসির বাসের কন্ডাক্টর হইতেছি,
একটি বাস যাহার
নম্বর WB39A3583 কলিকাতা হইতে আসানসোল অভিমুখে যাইতেছিল। জগাছা থানার অন্তর্গত জাসবির হোটেলের সামনে একটি ট্রাক যাহার নম্বর JH09E3884 আসানসোল অভিমুখে সরকারি এসবিএসটিসি বাসের সামনে যাওয়ার সময় হঠাৎ ব্রেক কষে, ফলে সামনের ট্রাকটি অবধারিতভাবে দাঁড়িয়ে পড়ে এবং নিম্নলিখিত বাসটি সেই ট্রাকের পিছনে ধাক্কা মারে। এমতো অবস্থায় এসবিএসটিসির গাড়ির চালক ভীষণভাবে আহত হয় এবং ওনাকে আশেপাশের লোকজন হাসপাতালে নিয়ে পৌঁছে যায় 7:45 নাগাদ। পরবর্তীকালে ওনাকে ফলস্বরূপ রাস্তার এবং কিছু যাত্রী সেই সময় নেমে এসে প্রাথমিকভাবে ওনাকে স্থানীয় আসানসোল এসডি হাসপাতালে নিয়ে যায়। This is what he has stated. He is a charge sheeted witness. There is, my lord, no evidence which states that there is contributory negligence. This issue has not been framed.
Eyewitness is one.
Eyewitness is one. Now, my lord, may I kindly come to the charge sheet? Kindly see, my lord, page 29. Who is the charge sheeted person? Column number 11. Krishna Yadav, son of Lallan Yadav, year of birth 28 years, male, Indian. Who is this Krishna Yadav, my lord? He is the driver of the offending truck.
No. Krishna Jadhav is this. Is the charge sheeted? Is the accused person?
He is the driver of the truck which was proceeding in front.
Yes, he is the accused.
Yes. Now, my lord, kindly come for once to the judgment, how the tribunal has dealt with all this evidence. At page 61, these two issues are issue number 2 and 3. These two issues are taken up together for the sake of brevity. It was the case of the petitioner that on 13/5/2013, while the victim was driving SBSTC bus along Durgapur Asansol Road, the offending vehicle which was proceeding in front of the said bus suddenly applied brake without giving any signal, and as a result thereof, the bus of the victim collided behind the truck, and on account of such accident, victim died in SSKM hospital on the next day. From the evidence of PW1, it can be seen that she stated that she heard about the accident from the conductor of the bus. She had stated that her husband died in a motor accident which took place on such and such. During her cross-examination, the factum of the death of her husband PW1 was not challenged. PW2 claimed to be eyewitness of the accident. He stated that on the relevant day he was taking tea in a hotel. He also stated that the truck bearing number such and such suddenly applied brake, for which bus hit the back portion of the truck by using control of the bus. by losing control of the bus. During
Portion of the bus.
During cross-examination, he stated that the bus was at a high speed and after hearing sound of dashing, he reached the spot within 2 minutes. He also stated that he, along with local people shifted the injured person to SD Hospital, Asansol. It can also be seen from the final report of Bhawanipur PSUT case number such and such that it was prepared in connection with death of the victim. It can also be seen from the postmortem report that liver and spleen of the victim was ruptured and there was bruise over his mid-abdomen. History of the case as recorded in the PM report also supports the case of the petitioners. Although evidence of PW2 suggests that the bus was at a high speed, but that was quite likely as the bus was proceeding along the national highway. PW2 stated during his cross-examination that there was no bus stop and the driver on the highway about 3 feet wide, suggesting that it was one-way traffic. In such circumstances, at page 62, my lord, nearly because of high speed of the bus, it is not possible to hold that there was negligence on the part of the deceased. On the other hand, evidence of PW2 suggests negligence on the part of the truck driver or driver of the truck in suddenly stopping the vehicle. Moreover, the fact that after investigation, charge sheet was submitted against the driver of the vehicle number such and such also shows that it was not the victim but the driver of the truck was at fault. Learned advocate for insurance company relied upon decision of Allahabad High Court passed in Premchandra Sharma versus Munna Verma, in which it was held that when a motorcycle dashed against stationary truck packed by the side of the road, driver of the motorcycle was responsible for contributory negligence. Fact of that case is completely different from present case, as here both the vehicles were in moving condition. Accordingly,
This Premchand.
well, that is for a stationary truck. This is a truck which was moving in both, which was moving, both the vehicles were moving. The evidence clearly suggests that there was sudden application of brakes. Now, my lord, they are saying that contributory negligence has to be attributed. Honorable Supreme Court time and again has passed several judgments which say only one thing, that contributory negligence cannot be apportioned casually. There has to be positive evidence for that. I humbly request, my lord, put only one question to myself. What evidence have they led? Not a single one. The issue was not also framed. So, my lord, there's no question of contributory negligence whatsoever. The charge sheet says that the truck drivers were responsible. The evidence suggests that the witness says that the truck driver suddenly applied brake. They say that it was in high speed. Of course, it was in high speed because it was a national highway. And the fourth point is they have not adduced a single evidence to show that there was ration negligence on behalf of the truck driver, on behalf of the bus. Now, my lord,
The bus driver. Behind.
Now, my lord, there can be no presumption, my lord. They had to adduce some evidence. There's no evidence. Now, my lord, let me, my lord, kindly come to my cross objection. My lord, the tribunal has, my lord, taken salary of the victim. I have, my lord, adduced 1 year's salary of the victim. He was an employee of SBSTC. A person was summoned.
1 year salary slips were filed.
Was filed. Now, my lord, this, my lord, for your lordship's kind convenience, my lord, I am giving this chart, which is also reproduced in the judgment as well.
I think page 63.
Yes, it is there, but my lord, I am giving this. This is just a tabular calculation, which shows, and this is on the based on evidence. From May 2012 to April 2013, this is the entire salary. Now, my lord, I have also paid income tax, which is in column number B, and I have also paid P tax.
No, these were the salary, these were exhibited.
These were exhibited.
Showing this gross salary.
Yes. My lord, kindly sees these are exhibit numbers, page 44 to 55 of the paper book. These are the exhibited documents. It starts from page 43. This is exhibit 13, my lord. Exhibit 14, starts from page 44.
Yes.
Now, my lord, this is a calculation. Why I have given this chart is to show, my lord, that these are the salary which is received by the victim for 1 year. My lord, after receiving this salary, he has paid income tax and P-tax. These two components should be deducted. After deduction of P-tax and income tax, the annual salary comes to 3,20,528 rupees. On the basis of that, the calculation which is coming for compensation is this. My lord, I have given this calculation.
Go to your learned friend.
I have given her a copy as well, my lord.
The question is, the learned trial judge proceeded on the basis of the last salary slip.
No. My lord, learned tribunal has also taken the entire salary slip into account.
Yes.
But one mistake that the tribunal has done
Yes.
is to deduct the pension amount, which he used to receive, sorry, my lord, provident fund amount.
Okay, provident fund amount is reduced.
Yes. That, my lord, I have got several judgments. If your lordships
No,
want.
only taxation and statutory deduction.
Yes, that is my only ground, my lord. And there's another ground.
No, babe, I think
That
PF,
I concede with.
no, I think PF only, suppose PF, a person has statutorily has to deduct,
Yes.
suppose 10,000.
Yes.
And it suppose 30,000, 40,000 is
Yes.
deducted.
Yes.
So to that
Only
statutory
that.
deduction,
Yes, my lord.
10,000, that has to be
Grateful.
deducted.
That
So
my lord
if
has been
it
deducted.
is, you see, minimum amount of GPF, okay, which has to be deducted under the law.
Yes.
That has to be deducted.
That has to be deducted.
So what was that? That is the question.
My lord, kindly comes once to page.
Is it different GPF in different months? It has to be uniform.
No, that is uniform.
Minimum deduction, that is statutorily the employer is bound.
Yes, that deduction.
Actually, you see, after all, so far, you see the Supreme Court decisions are concerned, it is stated only the tax liabilities and other liabilities. That has to be deducted.
Yes. My lord, I'll just, to assist your lordship, I'll just show the latest judgment with regard to PPF. My lord, kindly takes this judgment. This is past enough. This lists all the judgments which are there. My lord, kindly come to page 3, paragraph 4.
Yes.
The High Court, while considering the appeal preferred by the respondent number 1 insurance company, concluded that the Accident Claims Tribunal's approach while assessing the compensation under the head of loss of dependency was erroneous on various grounds. It was held that the salary of the deceased should be based on annual salary review for the year 2013, according to which the gross salary was such and such. The figure realistically reflects the deceased Suryakant would have received for the year 2013. The High Court took the basic salary of the deceased per annum for calculating the loss of income only on the said figure. The future prospect 50% were applied, which worked out to be such and such. Now, my lord, as per the High Court, the total loss of income, including the allowances, work out to 6,20,000. From the said amount, professional tax to the tune of 2,400 and income tax to the tune of 61,000 was deducted, and hence the total annual income of the deceased Suryakant worked out to be such and such, as per the High Court. The High Court in particular held that the components of house rent allowance, flexible benefit plan, and contribution to provident fund, etc., could not be accounted for the purpose of adding 50% to gross income of the deceased in the principle of future prospect. Now, my lord, kindly come to my lord, paragraph 6. Having heard and considered the submissions advanced by the learned counsel for the parties, and after going through the impugned judgments and the record, we are of the opinion that the reasoning assigned by the High Court that perquisites or allowances in the nature of house rent, flexible benefit plan, and company contribution to provident fund would have to be excluded from the gross income for the purpose of applying future prospect is erroneous on the face of record. There cannot be any two views on the aspect of that these perquisites or allowances admissible to a salaried employee do not remain static and continue to rise generally proportionate to the length of the service of the employee. These allowances are generally fixed on a pro rata basis with reference to basic salary. As per service conditions and pay scale, the government officials, the house rent allowance is payable between 80 to 30% of the basic salary. Therefore, the house rent allowance is paid on a fixed ratio proportionate to the basic salary. Now, my lord, kindly see the conclusion of this particular case. Paragraph 10 at page 7. Therefore, components of house rent allowance, flexible benefit plan, and company contribution to provident fund have to be included in the salary of the deceased while applying the component of rise of income of future prospect
Yes,
to
that is there.
to determine the dependency
This is
factor.
the latest decision.
Yes. So, my lord, my humble submission is only
Another
one.
thing is this, is there any evidence that whether this claimant's wife, this victim's wife received any compassionate appointment or not?
No, there's no evidence.
So let us see.
Yes,
The
kindly see, my lord.
examination in chief, any question was put or not?
Yes, the one question was put. She has said, we don't know. My lord, kindly come to page 22.
Yes.
My lord, my son, cross-examination, middle portion, my lord. My son is in service. My lord, kindly see.
Oh, I can't say whether any application was made by me for appointment of my son in place of my husband.
Yes.
For compassionate appointment.
Yes. After that, my lord, kindly see. My son is in service, but his income is very much low.
Different issue. But whether any compassionate appointment or any application is made or not.
No evidence, my lord. My husband studied up to HS but could not pass. I can't say whether any application was made by me for appointment of my son in place of my husband on compassionate ground. But my lord, there's no evidence. But in any case, my lord,
not received any account of ex gratia.
yes, nothing received, my lord. There's no evidence to that extent. And there is just one additional point. The age is incorrectly taken. The age, the multiplier should be.
Anyway, give your calculations.
Yeah, my lord, I have already given the calculation.
This one?
Yes. এটা দিয়ে দিন আরেকবার একটু
So you have proceeded on what? 11,773.
My lord, monthly income.
No. Give your calculation of compensation. It is only with regard to salary. No, you to salary.
My lord, my humble submission is, since the driver of the SBFCC bus dashed the truck from behind, it is evident on the face of the record, and no other evidence had to be brought in before the learned tribunal. So some type of contributory negligence be put on the driver of the state bank.
So how much was awarded by trial court?
Well, the trial court had awarded the awarded amount, my lord, is 18,29,770.
Okay, and according to you, it comes to 27 lakh.
My lord, after that provident fund is adjusted, it comes to 27 lakh. Remaining all the components are okay except the multiplier issue.
Okay, annual income according to you, it should come to 3,20,000.
My lord.
And the salary, which month salary is to be taken? Month salary?
12 months average I have taken, my lord. I have given the calculation. The total 1 year salary I have taken.
That is 3,20,000.
My lord, after deduction of tax.
Yes, so far the calculation is concerned. Do you have any objection? Calculation.
My lord, I have a bit of objection. My lord, this judgment may be recorded in your judgment. It may be reflected. My lord, para 17 of the judgment. In the considered view of this court, there
No,
can
no, these cannot be, you are confined. I thought you are giving for regard with regard to contributory negligence.
no.
These income view, this tax returns are applicable for business persons. For this,
No, my lord. Here it is given means in this judgment, salaried person and the business
anyway, you see,
self-employed
there may
person.
be, there you see, that it is discussed also. The issue was,
It has been very clearly discussed in the
and you
judgment.
see, the issue was with regard to business person.
No, my
This
lord.
person had a construction business, the victim.
My lord, let me take.
Here it is a
I've
government
gone through this
employee.
judgment. This person had a construction business.
My lord, para 18, my lord, see, we find the force in submission of for
See, these salary slips can't be disbelieved, okay? From salary, you see, the income cannot be enhanced and it cannot be reduced also. So what at best he has to pay the taxes. If he has suppose he has other incomes, okay? He has other source of income and he has not disclosed that. He has disclosed in his income tax return. That will not serve his purpose. He is confining himself only to salary.
And it is by government. There's no scope of
Paragraph 18,
manipulation.
yes.
this last part of the paragraph 18, my lord, see, a situation may also arise whereby the deceased or claimant might not have completed a year in the promoted position before the accident or might not have filed ITR for such period. In such cases, the court concerns take reference to the promotion letter and other corroborative financial positions. Salaried, in our view, for salaried individuals also, my lord, in this paragraph 18. And my lord,
Only you have submitted one decision
my lord,
with regard to this contributory negligence.
my lord, the permit was not valid and hence the pay and recovery.
Permit, and government bus driver permit is not valid.
Permit of
Okay, the state transport.
the truck
Okay, truck.
of which I am the insurer.
Have you proved that before the trial court?
Yes. My lord, that is their admission. My lord,
No, is there any observation by the trial court?
yes. ওই তো তুমি দেখো
And it is your ground of appeal also.
হ্যাঁ yes 62.
It's 62, my lord.
So last paragraph.
Page 62.
62 and 63. From exhibit.
Yes.
63, my lord.
63.
From exhibit D, it appears that the offending vehicle had national permit since 8/3/2014 and subsequent thereto, there was no permit prior to 8/3/2014. Therefore, it appears blah blah blah. কোথায় গেল?
Okay, there is a direction. Insurance company may recover.
Yes. So there's no, we don't.
Anyway, that liberty has to be granted. But in the operative portion, it is not directed.
Yes.
Well,
Yes, record and order. Learned advocates for the parties are present. Heard learned advocates. Hearing is concluded. Let this matter appear for judgment on 13/8/2026.
Deeply obliged.
I'm grateful, my lord.
12 p.m. will be taken up at 2 p.m. Lordship. Mr. Paul is present.
Yes, if time permits, I shall take it up.
Yes, Lordship.
Let's
Not
see.
12 noon matter. Not
2 p.m. I shall take up 2 p.m. matters. If there are if the advocates are not there for 2 p.m. matters, I shall take up the other matters.
I have a 2 p.m. matter.
Okay, I shall take up.
Paul is present. There is a 5 minutes time is taken. I believe Mr. Paul is present. It's 2 p.m. will be taken.
If time permits, I'll take it up.
Sure.
Yes.
My lord, this is my appeal, my lord. Here, this is a 163A appeal. My contention is that the girl who died in this accident was killed as per the FIR. My lord, please come to page 16 of the paper book. আমার বিনীত নিবেদন এই যে আমি শ্রী নন্দদুলাল বাগ, পিতা ফণীভূষণ বাগ, গ্রাম মাধবপুর, পোস্ট অফিস কল্যাণপুর, থানা নন্দকুমার, জেলা পূর্ব মেদিনীপুরের অধিবাসী হইতেছি। অদ্য 20-10-16 আনুমানিক 16 তো এটা আনুমানিক বিকাল 3টে নাগাদ আমার ভাইয়ের মেয়ে মধুমিতা বাগ 16 বৎসর, পিতা গুরুপদ বাগ, সঙ্গে সুমিতা বাগ 16 বৎসর, পিতা নরসিংহ বাগ, এবং পিঙ্কি নায়েক 16 বছর, পিতা রামপদ নায়েক, মাধবপুর কল্যাণপুর থানা নন্দকুমার মহিষাদলে টিউশন পড়ার জন্যে NH41 এর ফুটপাত ধরে গারুঘাটার দিকে হেঁটে যাচ্ছিল। আনুমানিক 3টে নাগাদ নন্দকুমারের দিক থেকে হলদিয়াগামী একটি দ্রুত গতিতে সুইফট গাড়ি, যার নম্বর WB30R6645, আক্রোশবশত খুব দ্রুত গতিতে এবং বেপরোয়া ভাবে গাড়ি চালিয়ে আমার ভাইজি মধুমিতা বাগের সঙ্গে থাকা সুমিতা বাগ এবং পিঙ্কি নায়েককে ইচ্ছাকৃতভাবে মেরে ফেলার উদ্দেশ্যে ধাক্কা মারে। ফলে ভাইজি মধুমিতা বাগ ও সঙ্গে থাকা 2 জন গুরুতরভাবে জখম হয়। স্থানীয় লোকেরা 3 জনকে জেলা হাসপাতালের ডাক্তারবাবু আমার ভাইয়ের মেয়েকে মৃত বলে ঘোষণা করে, বাকি 2 জনকে হাসপাতালে ভর্তি করে। 2 জন মৃত্যুর সঙ্গে লড়াই করছে। আমার পূর্ণ বিশ্বাস ড্রাইভার ও সঙ্গে থাকা ব্যক্তি পূর্ব পরিকল্পিতভাবে এবং ইচ্ছাকৃতভাবে 3 জনকে মেরে ফেলার উদ্দেশ্যে ধাক্কা মারে।
Yes. What is the charge sheet?
Charge sheet
Submitted under?
it changed the whole story.
What is the charge sheet? Let us see.
Page 19 of the paper book. The sections were changed, my lord. It was firstly 304 ছিল, 302 ছিল।
Yes.
My lord, this page 16 of the paper book, received on 2010-16 at 17:45 hours, started Mohishadal PS case number 399 of 16, dated 2010, under section 325, 307, 302, 34 of IPC. In the
The case was started.
Yes.
Yes. Now let us see. What is the charge? Case was started. Charge sheet submitted under which section?
Again, 302 was not there. Let us see, my lord. Brief fact of the case is that on 2010-16, OC Mahishadal PS received a written complaint from one Nandodulal Bag, son of late Phonibhushan of Madhopur, PS Nandokumar, district Purbo Medinipur, to the effect that on 2010-16 at about 15 hours, his niece, namely Madhumita Bag, 16 hours, along with her 2 other classmates, Shumita Bag and Pinky Nayak, were going to Mahishadal to take tuition on foot through footpath of NH41. But on way to Mahishadal, while they reached at Tajpur on NH41 near Garughata, Then one Holdia bound Swift Desire car bearing registration number such and such dashed his niece and her two classmates with an intention to kill them. As a result, his niece Madhumita and two of her classmates sustained grievous injuries on their persons, and with the help of local people, they three were shifted to Tamluk District Hospital, where attending MO declared Madhumita Bagh as dead, and rest two were admitted for treatment. The complainant believed that the driver of the said offending vehicle, along with his another associate, dashed his niece and two other vehicles in pre-planned manner with intention to kill them. On the basis of written complaint, the instant case was started, endorsed to me by OC Mahishadal PS for its investigation. I took up its investigation. Now, after this Vishwanath Koyal, IO, when he took up the investigation, he changed the case. My lord, there was a publication in a local newspaper that there was an event of eve teasing case, and these three girls protested, and that's why this neta of that area with the driver came and আমার কাছে, I can give.
Please the record.
During the investigation of this case, I B. Coyle visited the PO, prepared through the sketch map of the PO with its index, examined the available witnesses and recorded their statement under section CRPC, seized the offending vehicle bearing number such and such with all connected papers, and DL from PO, arrested driver of the offending vehicle bearing number such and such, namely Dibyendu Dash, Subroto Kumar Maiti, son of Dulal Chandra Maiti of Solat PS Bhavanipur, District Purva Mednipur on 2010-2016, and forwarded to the learned court of 21-10-2016. Both were released on bail on 4/11/2016. Examined the injured Shumita Bagh, daughter of nurse.
Your person was also there.
Yes.
Yes.
And recorded the statement of Shumita Bagh, daughter of Narsingha Bagh, Madhapur PS Nandakumar, judicially has been done on 14/12/16, and collected copy of statement. Another one injured, namely Madhumita Bagh, daughter of Gurupada Bagh, expired on 2010-16, collected injury report of Sumita Bagh, Pinky Naik, an inquest report and PM examination report and of the deceased Madhumita Bagh from Tamluk PS, where Dr. Ashok Kumar Paria, MO of Purva Mednipur District Hospital, opined that, in my opinion, death due to antemortem RTA causing massive head injury as a result of strike by heavy moving object. I examined the inquest officer and escort constable and recorded their statement under section 161 CRPC, collected a report from Tamluk office and expert opinion from FSL. As per kind order of the learned court, I returned the seized vehicle bearing number such and such to its actual owner on 14/12/16, except DL. In the investigation, it has come out that it was an accident, but it was a murder.
Okay, where is that evidence of murder?
Because
in that tribunal, where is that evidence that it is a murder? You have to go by the evidence before the tribunal. Yes, what is the evidence? How many witnesses were examined? This is PW1. That is the mother of the victim. So what is there in the chief? In the chief, it is accident.
yes. Page 10 of the paper book.
Yes.
I am Gauri Bag, wife of Gurupada Bag. Then her details. I have filed this case along with my husband Gurupada Bag. Madhumita Bag was my daughter who died in a motor accident which took place on
163A.
There was a story, my lord, which has been very nicely camouflaged by the charge sheet. There was a story, my lord.
Okay, now the victim's parents are saying what? Victim parents and the eyewitnesses.
No, they are
No,
not.
actually, the victim parents did not witness the accident.
Yes.
Let us see PW who has witnessed this accident.
My lord, this is a case under section 163A.
Any
So-
witness is there?
No witness. Is,
7 except PW1.
Nothing has come. Only the FIR was lodged then and there, and it was written in such a way. The paper cutting must be
After how many days FIR was filed?
on that day only. That day, my lord.
Okay, and claim
Then and
case,
there. The
claim
true
case filed
story
after?
came on that day. The true story.
Claim case filed on which day?
Immediately.
না কবে ফাইল হয়েছে দেখো আমার কাছে জানি না তুমি তুমি ক্লেমেন্টের লয়ার তুমি বলো কবে ফাইল হয়েছে আরে আমি কি জানি না
Same year, 2016 law.
2016.
See,
And
the
incident
day-
of
In 16,
he doesn't, you do not know the date of filing of the claim case?
it was filed on 23rd December 2016.
Sir, how many days from the date of the
After the charge sheet.
after charge sheet?
The charge sheet was changed, my lord.
Charge sheet was changed.
Anyway,
In
so
connive-
was the IO examined?
No,
No, my
Okay,
lord.
vehicle owner,
no. That is their duty.
do you have the decision of Justice Bhaskar Bhattacharya?
Mita Samanto.
Justice Bhaskar Bhattacharya with regard to 304, there is a decision, division bench.
Lordship, after that he finished, then I will say. this
No,
and
no,
that.
you submit. Your learned Mrs. Mukherjee has submitted. You submit. What do you want to say? It would be better if you come with the division bench judgment. Probably I have also dealt with that in another case.
Lordship, I have
I
got
have
the.
Rita Devi, I have bought the Supreme Court judgment on accidental murder, and
Yes, that was dealt by Justice Bhaskar Bhattacharya.
I have that judgment, my lord. Rita
The
Devi.
division bench judgment also.
I do not have that.
No, so far Rita Devi. Oh, this is Delhi High Court.
No,
No, it is Supreme Court.
No, it stated Delhi High Court.
No, my lord. Rita Devi is Supreme Court.
In the High Court at New Delhi. Anyway,
Yes, Lordship, the Rita Devi judgment.
this 304 in the case, there was an allegation of culpable homicide. Okay. In the division bench of Justice Bhaskar Bhattacharya held that yes.
Lordship, that is the difference. If Lordship is finished, then Lordship kindly, I am narrating the entire fact.
No, you should come to the legal position.
Yes, I'm
Facts is there.
Facts is there. I am not. I am just legal position. I'm trying to satisfy the Lordship. Lordship, initially that is the FIR. FIR is not a conclusive proof of evidence. After the investigation, police filed a charge sheet under section 217 and 304B, 304A. Lordship, kindly come to the charge sheet. This submission is absolutely beyond the record. Lordship, kindly come to the page 20. The operative part they did not read. I don't know why it is not read that. Lordship, kindly come to page 20. He just, Mrs. Mukherjee read that. During investigation, Lordship, I am narrating that. Lordship found. Lordship, the police taken a 161 statement. Lordship, aware who will give the 161 statement and who will give the 164 statement. That Planet Tribunal considered the 164 statement also collected by the police. Lordship, kindly the same paragraph, page 20. Kindly come to that. So did not read out. Lordship, kindly see during investigation case such and such, the available witness recorded 161. Lordship knows what the witness of the 161.
Yes, charge sheet witness.
Charge sheet witness, yes. Thereafter, Lordship kindly see. Then Lordship kindly come next sixth line.
এটা তো পড়লাম
After
পড়ে দিয়েছি হ্যাঁ পড়েছি
and Lordship kindly see district Purba under section 164 of the CRPC. judicially has been done on 14/12/2016. So 164 statement to the magistrate. That statement considered.
Yes, was this taken into consideration by the trial court?
Yes.
Let us see the decision.
Kindly just note down if this is that the 164 statement considered. And
Let us
in
see.
that very page 20, kindly I am showing that.
Yes.
That very page, kindly see. The father and mother is not so worried. The insurance company is worried. Why I don't know. Kindly see the just before the witness name. Kindly see 14. Guru Podobag is the father of the deceased. Then you kindly see Gaudi Bag.
No, Guru Podobag is the complainant.
Guru Podobag is the father. Guru Podobag is the complainant.
No, one.
No, Dulal
Oh, uncle is the
Uncle
complainant.
is the complaint.
So Guru Podobag is the father. He also the witness. Then you can Gaudi Bag. He is the witness. Then Shokan is the Norsingo Bag. Norsingo Bag is another victim. Here, Lord will find the name of the Norsingo Bag is the Governor. Yes, he is the Sumita Bag or daughter of Norsingo Bag. So they have collected a statement under section 164 before the magistrate. The magistrate stated that no, he is absolutely killed. They did not confess before the landed magistrate. Lordship, what is the contents of the 164? Would you kindly see the charge sheets are submitted in such a way? What is submitting? His mother is not suffering, but the insurance company is suffering. I don't know.
Anyway,
161, 162.
so the father is the witness in the charge sheet.
Yes.
But the uncle is the FIR maker.
The FIR maker. Lordship, forget about the FIR maker. Just to inform the police. Whoever informed the police don't know. Lordship, it is
Whoever
of the
is informed the police, সে তখনই ঘটনা দেখে করে।
File under section 302, sometimes lawsuit also deliver the judge and acquittal. Lordship, I am just judicially. Lord, so it is not the what is the contents of the FIR. The father and mother is there. And the mother has come to the court before the landed tribunal. And the charge sheet has been submitted. There is a Supreme Court judgment. There one charge sheet has been submitted. Then no question can be arise. The eyewitness is not required. That the judgment, the Supreme Court judgment, Ronji, plus that they press the judgment. Plus the judgment is that we are opinion the Tribunal High Court both are missing.
No, let us see what is the decision of Rita. Probably
Rita is not applicable in this case. I don't know why.
No, Rita is what?
Rita is lordship is the auto rickshaw driver is stealing some passenger.
Body found.
Body found. This is not the case. This has no relation with the case. It has no relation. And lordship kindly see that my content is 164 statement. That is not the 161 statement. The 164 statement, the victim and other girls are was walking on the road. That statement was collected by the police. Police also go to that extent. After that, mother has come and mother has deposed before the court of law. They did not put the question if the mother is suffering with the child is murdered. So he has no pain. The pain is suffering.
No, question is not. Yeah, the question of there is no question of pain. Whether the complainants of others have filed any Ranaji petition before the magistrate for reinvestigation.
Yes, that they did
That
not
is the question.
That did not do so. Yes, I am obliged. I am obliged, Lordship. That did not do so. That did not. They accepted the charge sheet. And if they challenge the charge sheet, they could have filed an application and
all these questions are answered in the division bench judgment presided by Justice Bhaskar Bhattacharya.
Lordship,
That
true.
decision.
But Lordship, here the Bhaskar judgment is 166 judgment. And this judgment,
But it is, you see, this after all road accident.
Yes.
That's
Lordship, kindly see. Lordship, kindly see that.
Yes, Rita Devi is discussed by the trial judge.
Yes, Rita Devi case has been placed there.
And I have Renu Devi also.
If you have any confusion, you could have asked the IO. And what is the use of the IO? Because of IO consider 164 statement. The 164 statement is not supporting the contention of the FIR, but FIR only to that the vehicle hit the victim and victim died, and police correctly cited the file charge is 160A. Why you are going to that extent? This cannot be denied in such way. You should have paper and appeal within the ambit of the Act 88. Motor Vehicles Act. You are going to the criminal case. If you are going to the criminal case, you are dissatisfied with the criminal on the part of the police authority, you could have asked them to interrogate. But you did not, because of the learned trial court, the learned trial court also not insisting to ask them, because of learned was seen that 164 statement is there. Once 164, what development he will do in appeal court? Only paper and appeal, there is statutory appeal. There is not the right of appeal. And owner did not contest, accepted that. That is the Mita Samanto lawsuit was rightly informed, supplied that reason. The Mita Samanto, once owner of the appointing vehicle is accepted the adverse presumption, did not appear before the learned tribunal. So adverse presumption may be drawn up. There is evidence under section 106 of the Evidence Act. Lawsuit aware that it is not required to place because of the 163A. What is the appeal in this court? What is the appeal in this court? Because may I putting the question? The paper and appeal. Father, mother, all are the witness. 160 statement the other victim girls. Their name individually disclosed in this paragraph. Not only ended by the 161. 164 is there. And 164 before the magistrate. And on the date, that is the 14/12/2016. They have given this on confess before the learned magistrate. No,
Anyway, compensation awarded is not challenged.
no, because of 165 lakhs is the what is that is his Mr. Mukherjee correct. He's not challenging the quantum because there is the question of challenge. What mood is required for that, Lordship?
I have challenged the fact that the vehicle has been used as a weapon to.
Okay, vehicle was seized.
Yes, vehicle seized, charge sheet submitted.
Vehicle was
Not only that.
used as a weapon to kill the.
Yes, always.
No, not always.
Always.
Not always. Not always.
So where do we get that?
So from the FIR, my lord, and the
Where and thereafter charge sheet? That charge sheet is
charge
not
sheet has
challenged.
been changed, my lord.
It is not challenged.
It's the Article 12. Charge sheet has been changed. Lordship, kindly see page 20. Then another. I consult the merit of the case with my superior and submit MOE of this case. Please to direct me some charge sheet. And charge sheet submitted and with the consent of the rather not the consent, only the consent that the father and mother and another father of the victim girl also present in the charge sheet name. Their name is appearing Gauri Bag, Noshina Bag, and Guru Bag. What more is required? I leave it to Allah. Is 160 here? What more is required to be proved?
Anyway, in the written statement, that plea was taken that it was a murder.
But
So,
he was taken
once
very,
he was taken,
very vividly.
that means he.
And how did the learned trial judge deal with that? That is the thing.
Yes, Lord. Page 44, paragraph 9. Last paragraph, last. You got it? Page 44?
Yes.
It comes from the evidence of PW1 her daughter. You kindly see. The mother has deposed. What more is required? His mother never said that he was harassed or killed in otherwise motive. He is accepted the charge sheet. The charge sheet they exhibited on the side of the claimants. Charge sheet has been submitted before the court of trial court from the side of the claimants, not from the side of them. So we accepted that. He did not challenge the same.
With connivance.
Always connivance.
There is a connivance with the owner and
For that evidence, I ought to have been examined. Yes, take down. Learned advocates for the parties are present. Hard learned advocates. The appellant before this court was an opposite party in a case under section 163A of the Motor Vehicles Act 1988 and is 2088 and is aggrieved by the judgment and award dated 30th January 2025 passed by Learned Additional District Judge, First Court, HON'BLE, Purbo Medinipur in MAC case number 594 of 2016. the case of the claimant before the learned trial judge may be summed up thus. On 20/10/2016, at about 3:15 p.m., the victim, since deceased, Udumita Bagh, was walking along the unmetal portion of NH41 Holdia, Mecheda Road, near Tajpur, Garughata, when a Maruti Swift car bearing number WB30 capital R stroke 6645 was proceeding from Mecheda side towards Holdia side at terrific high speed, recklessly endangering human life and safety of others, and knocked down the victim with great force and violating the traffic road rules. As a result, the victim sustained severe injuries on her waist, chest, legs, and head, which caused her death at the hospital and died on the same day. Rash and negligent driving on the part of the driver of the said vehicle bearing number WB30 capital R stroke 6645 within bracket Maruti Swift car was the sole cause of the pathetic accident, which could easily be avoided if the reckless driver would take proper care and reasonable attention at the material time, being devoid of ordinary sense of prudent driving. Stop. The victim, since deceased, was a minor girl of tender age. She was a brilliant student. Stop. She had all qualities to prosper her life in near future. Stop. The applicants lost their beloved daughter forever. Stop. They sustained mental shock, pain, and agony. Stop. Pursuant to the filing of this case, notice was issued upon the opposite parties. Stop. The opposite party vehicle owner did not contest the case. Stop. However, opposite party insurance company contested the case by filing written statements. Issues were framed and evidence was adduced. Learned trial judge, upon considering the evidence adduced and upon hearing the learned advocates, was pleased to dispose the claim case by observing and directing as follows. এখানে হ্যাঁ NCTs থেকে এত অবধি page 51 থেকে 52. Being aggrieved by the judgment and award passed by the learned trial judge, this instant appeal is preferred by National Insurance Company Limited. Stop. Heard learned advocate for the appellant and learned advocate for the respondent insurance company. A respondent claimants peruse the evidence adduced and materials on record. Learned advocate for the appellant submits that the FIR was lodged by the uncle of the victim, alleging that it was a case of murder. Stop. Thus, the claim case before the tribunal is not maintainable. Learned advocate further submits that the charge sheet is submitted by the police authority that an accident took place, which is totally contrary to the incident. Stop. Learned advocates relies upon the decision of United India Insurance Company Limited versus Gita Devi, reported at MAC APP 256/2007, High Court at Delhi. Learned advocates for the respondent's claimant submits that the police authority conducted investigation and upon examining the victim's father and other witnesses, as well as recording the statement of the witness under section 164 CRPC before the learned magistrate, the police authority submitted charge sheet under section 279, 338 and 304A of the Indian Penal Code. It is further submitted that the deposition of PW1, the mother of the victim, will go to show that it is a case of accident and not murder. Learned advocate also submits that the learned trial judge rightly passed the order. Before proceeding to decide on the issue, it is necessary to remember that a complaint may be lodged against the police authority either with regard to road accident or with regard to any offense. Stop. Merely a complaint being registered before the police authority does not go to establish that the offense is committed by the persons named in the FIR or by any unknown persons. When a complaint is lodged before the police authority, it is incumbent upon the police authority to cause necessary investigation and to ascertain as to whether the allegations made in the complaint are true and correct. Stop. Upon conclusion of the investigation, the police authority is to act in accordance with law. In the instant case, pursuant to the complaint being lodged, case was started by the police authority under section 325, 307, 302 and 34 of the Indian Penal Code. Stop. Upon conclusion of the investigation, the charge sheet was submitted by the police authority under section 279, 338, 304A of the Indian Penal Code. It further appears from the charge sheet that in the instant case, about 27 witnesses were examined, out of which the victim's father was also examined. Father and mother were examined. Moreover, statement was recorded before the magistrate, before the learned judicial magistrate under section 164 CRPC. Upon conclusion of the investigation, it is observed by the police authority that RTA due to mechanical as per statement of the witnesses and other evidences, namely PM report, injury report, MVI report, expert opinion of FSL, it is learned the case is RTA due to mechanical failure of the vehicle. Stop. Nowhere it appears from record that the report submitted by the police authority was challenged before the magistrate and prayer for reinvestigation made. Stop. When an investigation is taken out by the police authority and the report is submitted, the same cannot be discarded without examining the investigating officer. Stop. In the instant case, the investigating officer was also not examined by the insurance company. Upon considering the statement of PW1 and the charge sheet submitted by the police authority. This and the reasons assigned by the learned trial judge considering different judicial decisions. This court does not find it fit to interfere into the findings of the learned trial judge. In the facts and circumstances, this appeal FMA number 11. Yes, there is no challenge with regard to quantum, with regard to interest, nothing.
163A case, ma'am.
No, quantum 5 lakh is awarded.
None.
Interest?
Interest has, we have deposited it
No,
also.
interest, how much is awarded?
6%.
6%.
Okay. Hence, substances, this appeal FMA number 1103 of 2025 stands dismissed. The judgment and award dated 30th January 2025 passed by learned Additional District Judge First Court Tamluk, Purbo Mendinipur in MSC case number 594 of 2016 is affirmed. The appellant insurance company shall deposit the compensation awarded by the learned trial court along with interest, if not deposited, before the Registrar General High Court, Calcutta, within 8 weeks from the date of communication.
We have deposited.
No, I have stated if not deposited, within 8 weeks from the date of communication of this order. The claimants, respondents will be entitled to withdraw the compensation upon compliance of necessary formalities.
My lord, may that dismissed word can be taken as
I could have
disposed
used
of?
some other words had there been some scope of making some alterations. Because there is no challenge to quantum or interest, nothing is there. So there is no scope. Anyway, instead of 8 weeks, okay, you have deposited. No,
I have deposited way back in 2025.
Rashid, 3 PM fixed matter, 12 noon is the Passover matter. It takes about 5 minutes. Mr. Paul is present.
No, 2 PM fixed.
Not the 12 PM fixed, but then Rashid 3 PM. So by 15 minutes, I believe it is complete. It was a very 5 minutes or 10 minutes taken.
No, let us take the 2 PM fixed matter first.
That was over.
2 PM? Oh, 2 PM to over হয়ে গেছে।
দে ফাইলটা দে না, ফাইলটা দে।
There is only one appeal, no counter cross objection.
No.
Item 6.
Item 6 again. Yes.
My lord, two grounds I have taken, my lord. One for my lord, dishonor of premium check. The check issued by the owner of the vehicle towards premium, insurance premium, that was subsequently dishonored. And for such dishonor, my lord, insurance company has cancelled the insurance policy, and subsequently, my lord, the accident took place. Our case is that, my lord, since the policy was cancelled due to insufficient of fund or dishonor of check, the insurance company is not liable. And second ground, my lord, is, my lord, quantum of compensation, my lord, regarding, my lord, deductions and, my lord, parental consortium. These two grounds I have taken. My lord, may I place the first ground, my lord, regarding dishonor of check? Can you come to page 31 of the paper book?
Yes.
You have got it, my lord, paragraph 6A.
Yes.
That is the written statement filed by the insurance company. The pleadings.
The OP states that claimants have filed the above case claiming compensation of the from the owner of the vehicle PM Enterprise being policy number such and such valid up to such and such. The OP number 2 states that the vehicle number such and such was never insured with the OP as alleged. The OP states that the MP Hatching Products Private Limited is issued a check for rupees 70,424 dated such and such in the name of the OP number 2, that is the insurance company, being check number such and such of Union Bank of India Asansol. The said check was dishonored by the said bank for insufficient of fund by memorandum dated such and such. The said intimation received from the bank was dispatched to the regional transport officer Asansol by dispatch number such and such. Devasri Mukherjee was also informed by dispatch. Devasri Mukherjee was the owner. Was also informed by the dispatch number such and such dated such and such by letter dated such and such. That check memo number such and such dated 97/2007 drawn on Union Bank of India Asansol branch for rupees such and such was returned to the insurance company uncleared for insufficient fund. That is the pleadings regarding dishonor of check. Then come to the evidence part. Page 44. Page 44, Your Lordship, yes, kindly have a look at page 45, the relevant portion, page 45, Malad. Page 45, Your Lordship, Malad, paragraph 4. Yes. This is the original proposal form filled up by our agent Mita Chakraborty and signed by her on such and such. The proposer Devasri Mukherjee, owner of MP Hatchery Product Private Limited, signed on the proposal form. The proposal was accepted by Opu Chatterjee, employee of the OP number 2, which should be marked as exhibit. That MP Hatchery Product Private Limited issued a check for rupees such and such, dated such and such in the name of our company bearing check number such and such of Union Bank of India, Asansol. This is the system generated policy in the name of Devasri Mukherjee, original of which was handed over to her. This is the system is, my lord, when the check is deposited, it's being deposited with the insurance company, the insurance policy is original insurance policy is handed over to the owner of the vehicle, insured. There is a conditions that if the check is, the premium check is dishonored due to insufficient of fund or due to any other reason, that the insurance policy will be automatically cancelled. That was the condition of the insurance policy. Every general conditions in every company's insurance policy, these conditions are there. That is why original was given to the owner and the copy was filed. Generated policy in the name of Devasri, original of which was handed over to her. This is the system generated collection receipt issued to Devasri against check number such and such, dated such and such. In the said premium collection receipt, rupees 8425 was excess, which was refundable to the owner. In the policy, it was mentioned that in case of dishonor of premium check, that document stands automatically cancelled ab initio, which condition was accepted by Devasri Mukherjee. 5. Unfortunately, the said check was dishonored by the banker on such and such date due to insufficient fund, and the memo of bank was received by the company on such and such date, which bears the seal of the OP number 2, original of which should be marked as exhibit. The party never came to take refund of such excess. There was 6. Devasri Mukherjee was intimated by the OP number 2 that policy collection stands cancelled since inception, and we are not on risk in respect of the above policy, which was sent by courier service, speed post, bearing number such and such, and the envelope containing the letter was returned to the OP number 2 with endorsement not found on such and such date. This is the original envelope address written by our employee BC Pathak since deceased. The original letter was signed by Ranjoy Mondal, retired, which was contained within the envelope. The original envelope of the original letter is marked as exhibit. This is the original letter to RTO Asansol giving information regarding cancellation of policy since inception. Both the intimations were sent to the as per the dispatch number through courier service This is the original receipt given by the couriers, which should be marked as exhibit. Both the letters were signed by Ranojoy Mondol, administrative officer. All the signatures are known to me, official course of business. Thereafter, my lord, kindly come to page 48 is the cross-examination. In the cross-examination, my lord, it was tried to establish regarding
Vehicle owner did not contest.
Vehicle owner did not contest in spite of, despite notice of summons, did not contest. But it was in the cross-examination and in the claim application, the claimant has tried to establish the case that you have written letter to the owner regarding RTO receipt. There is no issue. The question is whether the owner of the vehicle has full knowledge or not regarding cancellation of policy, regarding dishonor of
the findings of the trial court.
Yes, findings of the trial court that regarding same that is
whether the court came to a finding that the policy was dishonored, the check was dishonored and the policy cancelled.
Check was dishonored.
No, whether the what is the findings of the trial
page finding starts from page 107. Page 107 may just the gist of the findings I tell you. The court held that
let us see
maybe the check was dishonored, but you have not intimated properly to the owner of the vehicle. But one thing, kindly consider the check was dishonored. It was not. I came to knowledge from my statement of account whether the amount which was issued towards check or premium.
Check was dishonored,
yes,
but it is not proved whether the vehicle owner was intimated.
Yes, that is the case made out in the claim case. The findings of the
what if the finding is this? There is no proof that it is communicated. So that is why the obligation is imposed upon you without any recovery.
Yes. Yes. I am ultimately I am praying for kindly.
We have to see if I disagree with the findings of the trial judge, then I have to grant you leave to recover.
Yes. Kindly come
and if I accept the finding, there is no scope.
Just Lordship, I have relied upon the judgment. Lordship is delivered the judgment. The judgment is Shobha de. Let's recollect that the Lordship judgment.
Yes.
And Mr. Paul, what is the submission advanced by Mr. Singh? The same argument advanced by Mr. Paul before the Lordship. And Lordship also consider this argument in this judgment, in submission in this judgment.
No, that the case was this vehicle owner was directed to pay. The court came to the findings that the check was dishonored and it was intimated to the vehicle owner. Okay.
Very belated stage.
Yes, no, that is there. Okay. So there is the findings of the trial judge that yes, so the vehicle owner was directed to pay, which was challenged by the claimant in this. So that is why I made that observation that yes, there will be right to recover and with certain.
But Lordship discuss the entire Supreme Court, Indrajit Kaur, Seema Malhotra, all entire judgment.
So that is there. Okay. But here, of course, that judgment will be followed. But here something is different. The trial court did not come to a finding.
Page 109.
Page 109.
One paragraph it appears.
Lordship, kindly see the second paragraph. I have gone through the exhibit F1 by which the OP number 2, that is the insurance company, claimed that sent intimation about the dishonor of premium of check to the owner of the vehicle numbers on 24/7/2007. It is submitted that letter was sent by the courier service, which was returned with the endorsement not found. But thereafter, insurance company not tried to serve intimation to the registered owner of the offending vehicle at any other mood. In observation, OPW1 deposed that he cannot say whether the Mukherjee informed about the dishonor of a check or not. Receipt of courier service has not been produced by the insurance company. Kindly mark it.
Receipt produced. Receipt produced.
আচ্ছা ঠিক আছে
Receipt produced.
ঠিক আছে তো OPW1 further deposed in this consideration that the relevant time postal department did not accept the registered post with AD for the reason they could not send the letter to the Debashree Mukherjee by registered post with AD. That is the explanation why they did not different mode of service. First thing service courier not found, but they attempt to register with acknowledgement due card, but post office refused to accept their article. That is
For that reason, they could not send the letter. No. What is the reason?
Because you kindly see, receipt of courier service has not been produced by the insurance
No,
company.
no, receipt is produced.
receipt
but
coming-
that was exhibited.
Yes.
That finding that receipt of the courier to Debashree Mukherjee was not produced before the learned tribunal. That was not correct finding, because at page 48 you also will find regarding receipt of letter.
So you see that this check was dishonored on 24/7, 2007.
7.
Okay, and the accident took place
Much thereafter.
after how many months?
Accident took place in Lordship on 30th August 2007.
August 7.
30th August.
Before accident, the check was dishonored.
Because the check was given. But Lordship, the judgment, then Lordship kindly see, postal department did not accept the registered post of the AD for the reason they could not send the letter to the Debashree Mukherjee by registered AD. To that effect, the postal department did not accept registered post with the acknowledgement.
No, with account, no evidence or document, or did not accept registered, no evidence or document has been submitted by the insurance company.
Yes, Lordship, but they refused the refusal of the postal department. They did not adduce any evidence.
Okay.
The learned tribunal absolutely disbelieve this position of the insurance company. It appears from the insurance certificate as well as letter of intimation exhibit F. The address of the registered owner is that Debashree Mukherjee, SB Gorai Road, Asansol, District Bardhaman, West Bengal, but astonishingly, the address mentioned in the envelope Asansol has not been mentioned. That Asansol not mentioned in the intimation letter.
No. What is there in the letter? What is mentioned?
So it cannot be said that the intimation letters sent through courier service is not proper address. It is the liability of the insurance company to send the intimation to the proper address of the owner of the offending vehicle. So considering the decision of the honorable court aforementioned from conduct of the insurance company, it is clear that intimation of dishonor of check in respect of the premium of insurance company not informed to the owner of the pickup van.
Okay, thereafter, this person did not enter into a policy with this insurance.
No. Regarding knowledge.
Suppose if that is dishonored, is it so that subsequently the vehicle owner came?
No, not at all. Because regarding knowledge, whether the owner has knowledge for dishonor of check or cancellation of policy or not, that knowledge is that the Supreme Court is very clear that until unless the owner has the knowledge for cancellation of policy, there is no scope to revalidation or take a fresh policy. Here knowledge comes from her bank statement. From her bank statement, a check was issued for ₹10. Whether it was deducted or not, from my bank statement, I can assure that whether that check, the check what was issued for towards premium, that was credited, debited or not.
But some excess amount was there that was not.
That was same. In fact, that the actual amount is dishonored.
No, but excess amount is paid.
No, that was not paid because
what you have stated that excess amount was not accepted.
When that check was issued, subsequently insurance company came. It is found that excess amount was paid, and insurance company endorsed that amount. That no, this is the excess amount. But when that amount, that the check was deposited with the banker of the insurance company, the entire amount has dishonored. So there is no question of excess amount to return.
Whether it is knowledge or there is a presumption. The law is that you have to intimate the that the check has been dishonored, you have intimated. It is not that on presumption you are silent over the issue that he has a knowledge he was dishonored or not dishonored. But they,
We have
intimated by way of courier service. They have tried to intimate.
Yes.
They fails to intimate because and they have also submitted before the court that the post office also denied to accept their service. That is cannot be acceptable.
Under CPC, courier service is also good.
Absolutely, absolutely. I'm not
There is no
disputing that.
issue.
Initial is this thing through
Lordships, all the courier service not intimated, only some of the couriers, the High Court also. Anyway, Lordship, that I'm listening. Because of on that, he is not found, it is returned. But
anyway, let us see the next.
Listen, that is the basic crux of this appeal, that the learned tribunal satisfied, the insurance company fails to communicate their intimation regarding premium of check according to liability casting upon the insurance company.
But it was accepted by the learned tribunal that yes, check was dishonored. Check was dishonored, no issue. But you failed to communicate that same to the owner of the vehicle.
How much? Yes.
That was the finding of the learned tribunal. That is why since the learned tribunal accepted that the check was dishonored, so therefore I am praying for recovery right. That is my.
If they want to recover it, then I cannot stand.
Question is, the tribunal has not granted you the recovery right.
Yes.
If I accept the findings of the tribunal, I cannot grant you that. If I don't accept, disagree, then only I can grant you the recovery right.
But here, tribunal accepted that the premium check was
with that you have communicated. Okay, that is the question.
If the communication, the Supreme Court is very clear.
Fastening a liability of several lakhs upon an owner, that is also not a matter of joke.
Supreme Court, in the Supreme Court is very clear.
So many things have to be taken into consideration.
Supreme Court in this
best endeavor has to be made because a person wants to get the vehicle insured.
Supreme Court in this context, Supreme Court is very clear. Initially, the judgment was that the dishonor of premium check is the dispute between the owner and the insurance company. The third party, the liability cannot be touched. The third party has no role. Thereafter, 2008, in National Didappa's case, Supreme Court says, Justice S.B. Sinha's judgment, Supreme Court said, no, if the premium check is dishonored and the cancellation insurance is nothing but a contract.
Yes.
If the premium check is dishonored and it was duly intimated to the owner and the regional transport authority, then the insurance company has no liability to pay compensation.
You see,
that is
the moment you see, the moment you communicate.
Yes. Didappa Lordship, which is the judgment is that before embarking on the state issue, Lordship, kindly see the judgment of what is our subject. Lordship, kindly action. Lordship, kindly come to next page 9. What was this case? The before embarking on the, Lordship, you got it?
Just a
next page 9, paragraph 9.
Page 9.
Yes, Lordship.
Paragraph 9.
Yes.
Before embarking on the said question, we may notice the admitted fact. Lordship, kindly see. Second respondent who was driving the vehicle was also owner thereof. The insurance company was remain valid for the period of 1797 to 98. Respondent number 3 issued the check on 97 initially. The check was presented encashment before the bank. The bank was dated 97, issued return memo disclosing dishonor of check with the remark fund efficient. First step when they were cancelled the policy of the insurance company. The same information was communicated to and information about also given to the article. So that information given. Once it is given information under this juncture, Lordship, kindly the last paragraph, Supreme Court allowed 142.
Yes.
And a pay and recover.
Yes.
But
No, here in Didappa's case, here Supreme Court has given 2 criteria. Insufficient fund, very well. You have to communicate the same, that fact of cancellation of policy. You have to communicate the same to the RTO and the owner of the vehicle. And you have to put the evidence that whether they have received only to send letter, that is not sufficient. Whether the acknowledgement, the criteria is acknowledgement you have to submit. If it is found that they have acknowledged receipt, then the insurance company has no liability to pay compensation. Rather, in the Didappa's case, since the submission, since the case was very old, that is what under 142, in exercise of power under Article 142, the Supreme Court directed the insurance company, you pay and just recover, because the money was deposited before the court under 142. That was under 142, that since the money is being deposited before the court, you please allow them to withdraw, you please recover the same. But the ratio is being decided. Ratio is decided once the knowledge, the insurance company put the evidence before the court that they have knowledge, that the owner has the knowledge.
Service has communicated.
Only the letter sent, that is not the sufficient. The sufficient issue is whether they have knowledge or not. If it is communicated, if it is found that the owner has fully knowledge about cancellation of policy, thereafter no steps have been taken by the said owner, in that case, Supreme Court is very categorically balanced. There are several judgments after that. That yes, but insurance company, there is a criteria that insurance has to prove that the acknowledgement is good enough. That is why, my lord,
it is a submission, it's a fair submission of Mr. Pal. But Lordship, your communication absolutely fails.
Yes,
Not-
I have to
consider the decision and the findings of the trial.
Yes,
judge.
yes.
Then
Now, what is there in with regard to quantum?
Regarding quantum, my lord. Regarding quantum, regarding future prospect, monthly or annual income, there is no dispute. Regarding deductions, can you come to page 112,
Page 112.
inner page 13 of the award. Unless you got it, my lord. Page 112.
The paper.
Paper.
Yes, yes.
Yes. My lord,
Yes.
unless you got it, my lord, first paragraph, second paragraph. Second paragraph.
Yes.
So the amount after adding future prospect will be 79,000 plus 31,600, that is rupees 1,10,600, that is a loss of dependency. The petitioners are 6 persons, so the dependents of the deceased at the time of year, 6 persons as per decision. Salavarma, after deducting 1/5 year,
1/4, very well.
One-
1/4 is the Lordship, I consider.
1/5, the tiny table deducted 1/5
Note that 1/4.
instead of 1/4.
Please, please.
Because 1 to 3, 1/3, 4 to 6 is 1/4.
Lordship, I am not disputing. Lordship, can
Above 6, 1/5 is the last.
please allow this.
Therefore, the deductions would be
1/4.
1/4 instead of 1/5. And thereafter, just penalty made paragraph from order in portion. Penalty made paragraph from order in portion. The widow of the deceased will be entitled to get compensation. Relationship got it, my lord? The widow of the deceased. Right. The widow of the deceased will be entitled to get compensation amount of rupees such and such plus loss of spousal consent of rupees 40,000. That is rupees such and such. Claimant number 2 to 6, children of the deceased is entitled to get remaining amount of rupees such and such each plus rupees 30,000 each for loss of parental consortia. 30,000.
Lordship also giving that.
No. That is filial consortium, because my lord, after in Panashati's judgment, after considering that no loss of love and affection
Yes,
or
that has
parental
been, we held against.
that is what parental consortium was granted.
Anyway, you give the calculation.
1 lakh.
Yes, both of you give the calculation, and with regard to right of recovery, I shall consider.
We are giving. Well, at a, ওটা ওই যে দিচ্ছে তো ফ্রেশ কাজ দিচ্ছে তো ওদিকে চল
না রিজার্ভ করবো না ওটা you give the calculation, I am reserving it for judgment. Yes, record an order. Learned advocates for the parties are present. Heard learned advocates. Hearing is concluded. Let this matter appear for judgment on 14/8/2026.
Kashyap, we'll hand over the
Yes. Court officer will hand over the calculation.
Yes.
I'm taking up another matter.
Yes,
In the meantime, you hand over the calculation.
Yes.
I am for the respondent, my lord.
9, you are for the appellant.
Appellant. My lord, I have filed this appeal mainly on 4 grounds. My lord, first of all is income. My lord,
না ঠিক আছে, এটা ইয়ে লাগবে না, খাতার মধ্যে ইয়ে করছিল। Yes.
in the claim application, page number 1 of the paper book, occupation of the person is service as canteen manager. But in that respect, no evidence has been adduced, no document has been filed, not a scrap of paper even in support
Any
of that.
employer is examined?
No. No employer was examined, and he stated that he was a service canteen manager under Mukesh Agarwal, PSC, Kolkata Police, and used to get rupees 15,000 per month. But in support of that, nothing has been filed. And in this regard, learned tribunal has considered his income as rupees 300 per day and 9,000 per annum. But I am disputing this also, my lord, because unless and until there is any document, the occupation could not be proved, any document or evidence.
Yes.
So, my humble submission before your lordship is that, my lord, the income may kindly be considered as notional income. This in the accident happened in the year 2021. I think 21. 1. So, rupees between 3 to 5,000, my lord, it will be sufficient.
Is the death case?
No, injury.
Injury case.
Okay, 3 to 5,000. Now, my second point is that he was not a permanent employee. His employment has not been proved. So, but the learned tribunal has considered has future prospect as 15%. It should be 10%, my lord. It should be 10%, according to Sorla Verma and my lord, Pranay Shetty judgment. Third point is that, my lord. May I
What
continue?
is this age? 57.
57.
So 10%.
10%. Now, my lord, according to my third
This
point,
is Robin Kumar Majhi.
Robin Kumar Majhi.
Yes.
Third point is that on the basis of a certificate of Dr. Vinoti Das, the learned tribunal has considered the permanent disability as 28%. Now, if your lordship kindly come to the certificate, my lord, it is in page number 7.
Certificate, what is the percentage recorded?
28%.
Percentage 28%.
Yes, ma'am.
And the nature of disablement?
Nature of disablement is tendering was both radial and ulnar shaft. Well, not properly, he could not bend his perhaps the radial and ulnar hand.
Page?
Page number 74, my lord.
74.
First thing is that, my lord, at first, the accident happened in the year 2021. Rather, my lord, more specifically, 1/7/2021. But the this certificate was issued on 22nd August 2022.
So this doctor was examined?
Yes, doctor was
So
examined.
let us see the deposition.
Yes. Deposition of Dr. Binoza 43, my lord, page.
Page
43. 43.
Yes.
I am a medical practitioner in the field of orthopedic medicine. I am in the occupation since the year 1996. I have a degree MBBS, a diploma orthopedic. On 22nd August 2020, I clinically examined Robin Majhi, aged 58 years, with a history of RTA on 1/7/2021. As per discharge certificate, SSKM Hospital, the patient suffered from traumatic closed fracture of both bones of forearm without distal neurovascular deficit.
After taking history and after clinical examination and examination of all medical documents, I am of the opinion the patient has suffered permanent partial disability to the extent of 28% due to painful stiffness of left forearm with painful and restricted movement with weakness of left forearm. I issued nothing. There was no permanent impairment, my lord, and no it was not unusable, my lord. I issued the certificate to that effect. This is the said certificate being written and signed by me, and it contains the signature of the patient. The disability certificate will be marked as Exhibit 12. Now, my lord, cross-examination. I have received a letter from Lord Advocate requesting me to depose in this case. I did not treat Robin Maji. This is the I did not treat Robin Maji between 1/7/2021 and 2/8/2022. The patient himself produced X-ray plate and report before me for examination. The same was not produced as per my instruction. Disability of 28% is based in my opinion. I did not provide breakup of such percentage of disability. I did not mention the loss of percentage of earning capacity in my certificate. I have assessed the percentage of disability in respect of the whole body, not a fact that my assessment as regard a percentage of disability is not proper, not a fact that the order of to help, in order to help Robin Maji to get compensation, I have prepared a false and certificate. Not a fact. Now, my lord, one thing, this evidence witness has stated that he has seen one X-ray plate. This date of X-ray plate is mentioned in the certificate, my lord. Page number 74. Page 74, my lord. Item number 4 under documents perused. X-ray plate dated 22/8/2022. That means that X-ray was done on 22/8/2022. So it may happen. This may be further future further development, my lord. It may happen for any other cause.
74.
Page 74, my lord. Under the heading documents perused, column number 4.
Injury report, discharge certificate, OPD ticket,
yes.
X-ray plate.
X-ray plate. X-ray plate dated 22/8/2022.
22/8/2022.
Accident happened on 1st July 2021. So this X-ray plate was also not taken at the time of the accident, my lord. And this may be further development, future development. This may happen for any other cause, my lord. Not for. So, my lord, I am disputing this 28% disability assessed by the doctor, who has never treated this patient. And another thing is that, my lord, he was not a. She is sorry. She is only MBBS D ortho. She is not a
orthopedic surgeon.
She is MBBS D ortho.
That means orthopedic surgeon.
Surgeon, maybe surgeon. But my lord, he has never treated the patient. She had no idea about that, how this
Not treated the patient after the accident.
After the accident, really. After 1 year.
I clinically examined.
Yes, after 1 year, she clinically examined the patient. After more than 1 year. And my lord, the certificate, the X-ray plate perused by the doctor was also taken on 28, that is after 1 year from the date of accident. And my lord,
1 year from the date of accident.
Yes.
Date of accident.
Date of accident, more than 1 year. Now, my lord, my third point is that, my lord, the fourth point. My fourth point, my lord, rupees 1 lakh has been awarded for pain and suffering and 1 lakh for loss of amenities of life. These are exorbitant, my lord. $1 lakh for awarding 1 lakh for pain and suffering and 1 lakh for
amenity.
Loss of amenities of life.
So these are also exorbitant.
Yes. My fifth point is that rupees 50,000 has been allowed for medical expense where no medical expenses has been proved, either by way of producing.
How much medical expenses?
Rupees 50,000. And my lord, 9% interest has been allowed. That should be reduced. And my lord, There were actually two vehicles involved. I've also taken again the ground of contributory negligence of done the.
Two vehicles are involved.
This is not an
So
important.
you usually appear for Cholamandalam.
No, my lord, ICICI Lombard.
You appear for ICICI
Generally.
Lombard as well as for National.
There are three cases. So, my lord, my humble submission before your lordship
That
is
has to be reduced.
it should be reduced.
Yes, what do you say?
And the London Tribunal has given pay and recover right that I'm not saying.
So where is that right?
Yes, my lord, they're given the right. Pay and recover regarding as the driver was not holding a driving license. My lord, we have proved it.
So anyway, I'll clarify that that pay and recovery you will carry out, but in terms of of an earlier decision of this court, you follow that process and pay and recover.
Yes.
My lord,
Okay,
regarding
pay and recovery is already awarded.
Already awarded. That is why I have not taken that ground.
my lord, regarding future prospect, 10% will be actually, not 15%. It's true, I admit it. Number two, regarding interest, my lord, has already, all cases 6%, so it will be 6%. Now, regarding disability, my London friend said that may happen by another reason, but there is no suggestion. So these things cannot be go. Another thing, disability certificate. Disability certificate actually did not challenge. By in this fashion that the disability assessed by 28% is excessive or high. No suggestion in this regard. So disability is accepted. No specific suggestion. Here suggestion is assessment percentage is not proper. This is not there is no specific suggestion in this regard. 20% is excessive or high or not according to a. So this is very, very vital in this case. The percentage of disability did not challenge specifically. Another thing, my lord, my London friends say, actually 11 latter, but 6 months are actually required to assess the disability. 1 month, 2 months, 5 months, you cannot assess the permanent disability. According to law, it must be 6 months, at least 6 months is required to assess the permanent disability. So it is after 11 months. Okay, all right.
13 months.
No, no 13.
Why, sir?
ঠিক আছে আমি দেখেছি
13.
This is another thing, my lord, regarding quantum. Now, come to my lord, my learned friend said there is no evidence. There is evidence. Oral evidence is also piece of evidence. My lord cannot ignore it. There are two types of oral and documentary. But the oral evidence is not, is also evidence. Now, kindly see page 19 of judgment. Page 19. Page 19, judgment. Page 19, my lord. Is the eyewitness to the occurrence. PW2. Actually, they purchase the vegetables from the market.
Anyway, the challenge is not with regard to findings.
Nah, regarding findings, not regarding quantum, I am telling. I am telling quantum. 300 per day has taken my lord, the London Tribunal has taken 300 per day as income.
Anyway,
now the evidence.
Cross-examination, what is his case regarding his income?
Income regarding the case is, my lord, actually they after purchasing the vegetables, they for the canteen, they are coming in a bus.
So let us see the cross-examination.
Yes.
Of PW1.
Yes. My lord, kindly cross-examination of PW1, kindly page 38 my lord. 38 হচ্ছে examination G, 39 my lord, 39.
39. Yes, I was a permanent staff of the canteen.
And it is corroborated by PW2 that he was the canteen manager.
Oh,
That is the
canteen
evidence
manager.
of PW2. Yes, he was the accompanying person. He is the eyewitness to the occurrence. He said that he was the canteen manager at that time. That is the evidence of PW2 part 2. Corroborative piece of evidence by PW2, they accompanied at that time of accident.
PW2
Yes, my lord. Parts of Bhattacharya.
corroborate the accident.
Along with the accident. He was present at the time of accident.
Accident as well as employment.
It is denied, my lord. In the last in page 39, in last para, I used to receive my salary in cash, not a fact that I have stated falsely that I used to receive this
I
money.
was saying
I was a permanent staff of the said canteen. Was.
Evidence is going on later on. It is taken later.
Yes.
Evidence of PW page 42.
42, yes.
I have received the letter from London advocate, proper acquaintance of the London, not a fact that I have been taught by the state, not a fact that I have stated that false. I did not witness any accident. I have no document to prove that I have. In that question regarding PW2, no question was put to the witness regarding income. No question.
Our canteen manager.
Canteen
and
manager. That is PW1, canteen manager.
Any suggestion with regard to this? He being a canteen manager, he being a canteen employee.
Canteen manager actually by
this a victim?
PW2 who was also the employee. Yes, yes. He told that he was the canteen manager at the time of accident. He told. That is the evidence. That is written by the learned tribunal. The evidence or stated in the by the learned tribunal that he was the employee. When he discussed the 300 part, he discussed everything. And I would kindly see page 25. Page 25. Claimant has failed to prove his monthly income by adducing documentary evidence. And on page 25.
What did he say regarding monthly income? 15,000.
15,000.
Which the tribunal considered as
300 per day, 9,000.
9,000. Yes, now that is there. So PW2 has corroborated.
Yes, my.
Now the deposition of the doctor.
Yes. Doctor's evidence did not challenge the percentage of disability. There is no specific challenge by percentage. So percentage to be admitted. So it will go.
Doctor has in cross
only
examination
not go regarding the 10%. It will be not. I already said that it will be 10% future prospect, not 15%. That I admitted. Interest is 6%, not 9%. I also admitted. Regarding penance happening,
in the hand. Okay. Only in the hand, not lower portion.
No, hands. Yes. Hands is also very vital parts of the body, my lord.
Right or left?
Left. Board radius and anna. Left. Board radius and anna fracture হয়েছে।
Internal না left হতে পারে right হতে পারে।
হ্যাঁ left এরই। এটা left এ। And internal
both radius and ulna.
Right.
Shaft. Left or right, that is not mentioned.
Yes, left mentioned.
এই তো সার্টিফিকেটই খুলেছি।
তুমি এতে দেখো না, তোমার ডিসচার্জ সার্টিফিকেট দেখো না। Go to the discharge certificate. Left. এই তো left. Discharge certificate left. Injury report left. Injury report
Does not
left.
indicate that.
Discharge certificate also indicates, and also the
Certificate of
injury
disability
also.
does not indicate.
After discharge, he also go to the outdoor for outdoor treatment as outdoor patient.
Discharge means initial after the accident.
Yes. After the
Thereafter,
accident,
disability is by this Dr. Binoti Das.
yes.
After 1 year. Within this 1 year, anything may happen.
Where is the evidence? Where is the evidence to that effect? May happen. Is there any suggestion to that effect? No. It is all assumption or presumption. We not. Four corners of evidence, there is no evidence. No evidence at all. It's an assumption. It will not go.
But in reply, my lord, may be permitted to say something. My lord, if your lordship kindly come to the evidence of Binoti Das, my lord, my learned friends are suggesting that no suggestion is given to deny this. I'm coming to that point. I'm coming to that point. That হচ্ছে বিনতি দাস হচ্ছে
44, page 44.
44.
Yes.
43, 44.
44.
I did not, the petition himself produced the X-ray. Same was not produced disability. I did not prove the breakup percentage of disability. That means
is not proper.
She has not assessed properly as breakup is not given. I did not mention the loss of percentage of earning capacity. I have assessed the percentage of disability in respect of the whole body. Not a fact that my assessment in this regard of percentage of disability is not proper. My lord, this has been recorded by the Senate judge. This has been learned. So if we consider this on in what perspective the learned judge has noted this point, the question must be that your percentage of disability is not proper. That is why in reply the learned judge has
which she has denied.
Yes, in this way it has been denied. Percentage of disability.
There is specific.
It is denied, and my lord, regarding the my lord evidence of PW2, my lord, PW2 actually adduced evidence as an eyewitness. As an eyewitness, he has not stated anything about income of the victim. He has not stated anything regarding income of the victim. And victim himself stated that he used to get salary in cash, salary. Then where he has not been able to prove the salary. So the national income will come. This is my humble submission.
Yes, take down. Learned advocates for the parties are present. Hard learned advocates. The appellant before this court was an opposite party in a case under section 156 of the Motor Vehicle Act 1988 and is aggrieved by the judgment and award dated Seven 2024 passed by Lanet, Additional District Judge, Second Fast Track Court, Alipur, South 24 Park. Top. Case of the claimant before the Lanet trial judge may be summed up thus. Column. On 1/7/2021, at about 12 hours, the claimant aged about 57 years in injuries, a motor vehicle accident at the crossing of Khidirpur Road and Khidirpur Road and Red Road crossing while he was traveling by a minibus bearing registration number WB9-1996, which was being driven in a rash and negligent manner. Stop. The driver of the bus hit a motorcycle and completely lost control over his vehicle. Stop. He was taken to SSKM hospital and sustained permanent disability owing to grievous injuries, including trauma in his head, open fracture of radial shaft and ulna, and was admitted for 9 days in the said hospital in between 1/7/2021 and 9/7/2021 and underwent surgery. Stop. He was a canteen manager under Mukesh Agarwal at PSC Kolkata Police, earning rupees 15,000 per month. And due to the said accident, she has become permanently disabled and hence filed this case for compensation. Stop. Pursuant to filing of this case, notice was issued upon the opposite parties. Stop. The opposite party, vehicle owner, did not contest the case. Stop. The opposite party, insurance company, contested the case by filing written statements. Stop. Evidence issues were framed and evidence was admitted. Stop. Learned trial judge, upon considering the evidence and upon hearing the learned advocates, was pleased to dispose of the claim case by observing and directing as follows. Page 27. The appellant, National Insurance Company Limited, being aggrieved by the judgment and award passed by the learned trial judge, has come up with the instant appeal. Stop. Learned advocate for the appellant submits that the learned trial judge erred in considering the income of the claimant as rupees 9,000 without any proper proof and documents. Learned advocate further submits that the disability assessed by the learned trial judge of 28% on the basis of the certificate of a doctor who did not treat the claimant is excessive. Learned advocate also submits that the compensation awarded on account of pain and sufferings and amenities as well as medical expenses is also excessive. It is submitted by the learned advocate that the interest ought to have awarded as not 9%, which should not be, and the interest ought to have been 6% per annum. But it should be reduced to 6% per annum. Learned advocate for the claimant's respondent submits that no suggestion was put with regard to X-ray plate of the claimant, which was considered by the doctor being PW3 while assessing the disability. Learned advocate further submits that the date of accident and the date of treating the patient with regard to disability is not an unreasonable period. Stop. Learned advocate also submits that the fact that the claimant was a canteen manager is corroborated by the evidence of PW2. Upon hearing the learned advocates and considering the first facts of the case, this court is of the view that the claimant, who has claimed himself to be a canteen manager, has specifically stated the name of his employer being
Future prospect, my lord.
No, just a
Sorry
minute.
to interfere, my lord. Future prospect,
Just a minute.
10 and 15.
Name of the employer.
Mukesh Agarwal.
Name, yes,
Name of the employer is Mukesh Agarwal.
Mukesh Agarwal. And has also faced in the cross-examination such evidence with regard to his occupation as canteen manager cannot be disbelieved. Moreover, the evidence of PW1 claimant is corroborated by PW2 with regard to his being in occupation as a canteen manager. As the occupation of canteen manager is accepted considering the price index and the remunerations paid with regard to such categories of employees, it was not unreasonable to consider the daily income of the claimant victim to be rupees 300. With regard to the future prospect as argued by the learned advocate for the appellant, that the future prospect cannot be 15%. This court is of the view that such submission has some substance and the future prospect should be 10%. With regard to the assessment of disability, it appears that the witness PW3, Dr. Binoti Das, has given the particulars of a treatment, and considering the particulars of a treatment mentioned in the evidence as well as in the certificate, and considering the percentage of disability, this court is of the view that the learned trial judge did not commit any error in accepting the disability of 28%. With regard to the submission of the learned advocate that the compensation awarded on account of pain and sufferings, loss of amenities, and the medical expenses is excessive, this court, upon considering the period of stay in the hospital and the nature of injuries suffered, does not find any justification to interfere with the award of granting 1 lakh each for loss of amenities and pain and sufferings, and rupees 50,000 on account of medical expenses. Yes, have you calculated how much it comes if 10% is the disability, 10% future prospect is there?
Regarding interest.
No, let the future prospect, whatever is there, I am not altering 7 except the future prospect.
No, 10% হলে হবে হচ্ছে
9,000
800 10,800 800 যোগ হবে 800
into multiplier
5,000 কমে যাবে দুবার, ওটা ঠিক আছে, ওটা নয় নাই দিয়েছে, ওটা ঠিক আছে।
multiplier কত দিয়েছিলেন না?
আটানব্বই 200 ইন্টু 9 কত? 98 200 ইন্টু 1,18,200 ইন্টু 9, 1,18,200 ইন্টু 9, like it will be 1,63,000 ওটা হলো এটা 10%,
Only that 10% future prospect, others are kept intact.
intact. Actually, 10,800. So less. না, 8,000 এটা 18,000 এটা 24 না 1,24,000 হচ্ছিল ওটা 1,18,000 নয় কত হলো? টাকা 18,200 করে কিছু কত?
হাজার ইন্টু 1,000 প্লাস
1,18,000
10%
ইন্টু and it will be 10,63,800.
5,49,376.
5,49,000.
376.
If the future prospect
10%.
10%. And how much is awarded?
5,62,984.
Anyway, I'm not entering into the calculation. It's a minor difference.
Yes.
No, if we calculate the interest, that will be substantial.
Anyway, although the future prospect is considered as 10%, however, this court is of the view that instead of going into the arithmetical calculation, it would be just and reasonable to award the claimants respondents rupees 5 lakh. Thus, this appeal FMA 721 of 2024 stands disposed. The judgment and award passed by learned Additional District Judge, 13th Court at Alipur, South 24 Parganas, stands modified to the extent that the claimants respondents are entitled to rupees 5 lakh from the Appellant National Insurance Company Limited. The Appellant National Insurance Company Limited shall deposit rupees 5 lakh along with interest at the rate of 6% per annum from the date of filing of the claim case till today. In the event the compensation awarded is already deposited, no further deposit be made. The claimants respondents will be entitled to withdraw the compensation upon compliance of necessary formalities. Balance amount, if any, be returned to the Appellant National Insurance Company Limited.
Along with accrued interest.
Yes?
Along with accrued interest. Accrued interest.
Yes, yes, along with accrued interest.
Much.
Deep love, like no. Deep love.
So, okay, balance.
I'm asking for the respondent team, sir. I am for the plaintiff. There is also one application my lord has fixed today for a final decision of this appeal. The appeal is preferred on 2 points. One is pay and recovery in a case of a fake driving license. And second point was that of the quantification. But I am on the first point.
Are there any findings that the driving license is fake by the trial judge?
Yes, that I will show. If your lordships wants that thing first, then I will go straight to it.
No, your challenge is this pay and recovery.
Yes.
As well as the quantum.
Quantum, but I can't say that taking 250 rupees a day can be something on the lower side. Also, I cannot say that I concede for the insurance company, but evenly I say it is not on the higher side. That I cannot say. So I will go to the page 24 of this appeal, straightway. Twelfth line, if I am not wrong. 12th line.
Yes.
There has been, my lord gets it. May I read, my lord?
Yes.
Learned lawyer. It starts
Page 24
page 24
of the paper book.
of the paper book.
Which paragraph you are reading?
No, it's
Okay,
it is
learned.
the judgment.
Okay, learned lawyer has further submitted.
Learned lawyer has further submitted, although the driver of the offending vehicle possesses a fake driving license at the time of the accident, but the insurance company cannot be permitted to avoid its liability on the ground that the time of the accident, but the insurance company cannot be alleged to avoid its liability on the ground that a person driving the vehicle at the time of the accident was not duly licensed. This is what is the observation, because this has been already admitted by the advocate appearing for the
Vehicle owner.
no, for the applicant.
Applicant is concerned with his own rights.
I'm coming to
He
this.
will not he will not argue about the right of vehicle owner, nor he will argue about the insurance company's right.
Very true.
He is interested to get the compensation.
Yes.
And yes, with pay and
Very
recover.
well, very well.
recover it from the owner.
Right.
So
Now, first
whatever
of
the court will think fit,
yes,
has to
now,
consider.
Court has taken that court never discussed it at all. If that is a issue, and that is an issue. If your lordships kindly comes to page 21, issue number 4.
Yes.
Whether the driver of the offending vehicle had valid and effective driving license at the relevant time of the accident. That was one issue. If the learned court doesn't say about this, then that issue has not been decided at all.
Okay, issue number
4.
4.
Yes.
Was not considered.
Yes.
Yes.
Now, before I further move into this, my lord, I would like to take the notice of this honorable court that this policy, which is at page 57 of the memo,
Yes.
it is not a private car. It is a pickup van, which will be disclosed there. GCB public carrier other than three-wheelers package policy. If you come to the middle of it, your lordships will find that it is financed by Tata Motors Finance Limited in the middle of it.
So middle
of the set page.
Tata Motors.
Yes. And this is the branch is also stated, and it is that this is a commercial policy, commercial vehicles policy. This is that. Now, my lord, I will go straight to the burden of insurance company to prove whether that the policy was a fake or not. That was
policy or vehicle license.
Fake. Yes, license of the driver of the offending vehicle was fake. That was our standpoint.
Yes.
So I will go straight into that.
Was any license recovered from the driver?
Yes, that I will show in the Caesar list.
Yes.
Lordship kindly comes to page 37 at the bottom, paragraph 8.
Paragraph 8.
Yes, the last one, the bottom one. One driving license having DL number 55897. Issued by District Transport Office, Bongaigaon, Assam, in the name of Ramjan Ali, son of Rafiqul Ali, of so, valid up to this.
Yes.
Now, this is contradicted by page 55, by the document which is Exhibit B at page 55.
Page 55, yes.
Yes. This was from the office of the district transport officer, Bongaigaon, Government of Assam. They have stated in the middle of it, it is regarding the subject is regarding the information under RTI Act 2005 of the DL number 55897, about the same driving license. Now, thereafter they say, this driving license is not issued from the office of the undersigned in the name of Ramjan Ali, son of Rafiqullah Ali. So, Caesarly says so, but the PVD, Government of Assam, they say it has not been issued at all. Now, we have further filed one further document which has gone down as Exhibit A in page 53. This was the investigator that even after every accident case is filed, the investigator is appointed to collect the documents and to verify the same. Now, while verifying, he has come up with this and he has supported this document in page 55, and he has given a letter where he has said that the original, return the original with the intimation that DL number 55897 stands in the name of this driving license is not issued in the office of records.
So whatever was seized, that is proved to be fake.
Yes, if I say...
Okay, let us come to the seizure list again.
Yes, please. This is page 37.
37.
Seizure list, it starts with, after the reference of the case, article seized. This has not been referred by us. This has been referred by the applicant, is the respondent here. In paragraph 8, it is written, one driving license having DL number 55897 issued by District Transport Officer, Bongaigaon, Assam, in the name of Ramjan Ali. The same thing, my lord, if you are
the accused of the case.
Is the accused of that case. And now if you come again back to 55, page 55, the same driving license 55897 in the name of Ramjan Ali, son of Rafiqullah Ali, same. It has not been issued at all from the office of this undersigned. From where it is stated as issued, the government of Assam says it has not been issued by this office at all. So on the very face of it, it is a fake policy. Now, interestingly, if your lordships kindly comes to opposite party number 1 is the owner of the vehicle. If your lordships kindly comes to page 16 once.
Yes.
They have filed one written statement. It is not gone down as totally ex parte. But they choose and rather opted not to come before the tribunal to rebut the principle, to rebut the very factual evidence laid by the insurance company that the driver had a fake policy. They have filed this.
Driver was examined, vehicle owner and driver.
No, vehicle owner has been impleaded as a party.
Vehicle owner was examined by the insurance company as their witness.
Because they are arrayed as a party to the process.
Maybe, but vehicle owner and drivers are examined.
That was not
when
done.
dispute arises.
Yes, but
with regard to these issues, this driving license.
Yes, we depended and vouched on the papers. The papers, the government papers.
See, that has to be laid before the witness, so that he can be cross-examined or
Very well, my lord. But the question is, if someone is arraigned as a defendant
No.
and he has filed one written statement, can I call that defendant
Yes.
to come?
You see, 170 petition is allowed so that you can take all the necessary pleas.
Yes, that I have taken.
So when you get the benefit of 170, you can examine the IO, the vehicle owner, the driver, so many.
That has not been objected anyway because the IO seizure list or the charge sheet that has not been deprecated by
You see, if
either of the contesting parties.
whatever it is, you see, if the court is to pass some order, you have to examine these parties as witnesses. This is the evidence of insurance.
This is not the evidence. It is a written statement filed by owner of the vehicle.
This page
Then
16.
thereafter they chose not to come up. This is 16, page 16.
Page 6A, your lordship.
Huh?
Page 6A, after page 6.
Page?
Page 6A, capital A. After
Oh,
page
I'm so sorry. 6A then, because
Page
it is there. I could not understand.
written statement filed by OP number 1.
Yes, that is
Registered.
the owner of the vehicle. And what he did, if your lordships kindly comes to the very bottom of it, if your lordships gets it. Para 9. The OP does not admit any such accident as alleged in the claim petition took place arising out of the use of vehicle number this, also denied the responsibility of the driver of the alleged vehicle bearing number this.
Anyway, he has denied
He has denied what? He has even denied the very use of the vehicle.
So, you see, he may deny many things, but the police authority has investigated, submitted the charge sheet.
That they have.
Upon considering the evidence,
Yes,
trial court came
and
to a
that
finding.
we are also vouching. We have also vouched that the applicant vouched.
Now you
We
see,
have also.
no owner will say that yes, the driving license is fake. Okay. So
No, he has to state because we have filed the written statement alleging the fact, if at all I have alleged.
written statement, did you say the driving license was fake or?
Yes, of course.
Subsequently, you have stated.
No, I am not subsequently because we received the notice and we have come up.
What is that in written statement?
I'm showing you.
In written statement, there's nothing that is driving license fake.
That the driving
Just
license
a-
fake, because
just a minute.
you have come to know after getting the report. Anyway,
Yes, of
subsequent-
course. How can I? If somebody gets an unfortunate accident after filing of the case that we comes to learn, and accordingly we investigate, we put an investigator, and thereafter when the report comes, we file the written statement. If your lordships kindly comes to, if it is page 5, no, 6. এটা পাঁচ। না, এটা তো আমাদের written statement, আমাদের। Page 5. Comes to page paragraph 6. It is submitted that the alleged driver of the vehicle was not holding any valid and effective driving license at the time of the alleged accident, and further was not qualified for holding or obtaining such driving license, and further is not satisfied with the requirement of this.
See, not holding valid driving license is one thing. The validity period will expire. And fake is another. That is a
Very
serious
correct.
charge.
Very correct, my lord. I appreciate. But the question is, supposes that we appear by filing one application, by filing a written statement and having received the notice. Thereafter, we start our process of investigation.
And all this.
Yes, and then we comes to learn about this. There is no denial by the complainant or anybody else regarding this. And even they have admitted that they do not have the proper valid license, but the insurance company cannot be relieved on that particular point. We also say nothing on this. This is the situation when there is an admission from the part of the applicant itself. They cannot both approbate and reprobate in the same way. That cannot be done. And we have simply said nothing on it. We have proved our burden. Now the onus shifts on the owner. If he comes up, if he sees that this order has been passed, Now it comes to the owner to disprove the fact that he was not having he was having a right license. That was not there. And he simply is a defendant in the proceeding. I have taken the defense of 170 because I know that in any manner.
If you can evade responsibility.
Yes, because I cannot evade to the third party.
Yes.
Because that is a
debate.
yes, that is the social legislation. I cannot. But knowingly that even some commercial vehicles owner keep quiet in the house, that cannot be construed as that of the primary duty of the insurance company to see if something is proved on the very face of the report that it is a fake license given by a government authority, and thereafter we need to prove it further by calling upon the owner to come or the driver to come and to say what the driver will say. It's not a criminal proceeding. In a case of a criminal case, it has got certain validity. But when it is a case of
Anyway, there are
social
decisions-
legislation,
There are decisions that in cases where this dispute
My lord,
driving license.
very true. Very
so
true.
vehicle owner's examination and driver's examination
My lord,
is necessary.
here,
And IO's examination also.
yes,
What IO has collected. Whether
yes.
IO
IO has filed this scissor list. IO has filed the charge sheet. It is there. And if I find it is in order, why I shall contradict?
and whether
I am not going to contradict.
IO has submitted charge sheet, whether he
Yes.
has submitted charge sheet for holding fake license.
That is the certified copy has been filed.
Anyway,
I am filing the, I am discharging my burden by placing some document which shows that the document that has been seized by the IO, which is said to be the document driving license of the driver of the offending vehicle, as is not at all issued by the PVT government of Assam. In that event, my lord, as to my understanding, the appreciation of the court must goes at the same time with Sarala Verma case. I'm not talking about Sarala Verma. Just a minute. Swaran Singh. I'm so sorry. Swaran Singh.
that is the pay and recovery. Swaran Singh.
Yes. Swaran Singh has said that I will not affect the right of the claimant because it's a social legislative policy. Here it is a case of a commercial policy. I do have a privity of contract between the car owners and car owner and that of myself.
Let us see what is the findings regarding, you see, your
He
ground
said
of challenge
nothing.
is the quantum, okay?
Yes.
And second is this non-granting of the right of recovery. So let us see with regard to findings of the fake license. What is the
No
finding?
findings. I could not find any, my lord.
You know, so kindly come to page 24, the same page.
24.
Page 24, the same page. The learned friend submitted. After 12 lines, your lordship, may I read, your lordship?
Yes.
The learned lawyer has further submitted that although the driver of the offending vehicle possesses a fake
Learned
driving-
lawyer of Clement.
Your lordship,
Yes.
possesses a fake driving license at the time of accident, but the insurance company cannot be permitted to avoid his liability only on the ground of the time of the accident, but the insurance company cannot be alleged to avoid his liability only on the ground that at the time the person driving the vehicle at the time accident was not duly licensed. It is not accepted of the employer to verify the genuineness of the driving license from the issuing authority at the time of employment. It is open to the insurer to take a defense that the driver of the vehicle involving accident was not duly licensed. Once such a defense is taken, the onus is on the insurer. In the present case, the insurer failed to prove the willful negligence on the part of the owner to take appropriate step. This is the land of the law, your lordship. This is the law of the land, your lordship. And kindly see the cross-examination of DW2. Page 19A.
Yes. This is what insurance investigating officer.
No, no. This is the insurance
Insurance officer. Your Lordship.
administrative officer.
Okay.
Administrative officer. It's a cross-examination, third line. It is not possible to say any driving license fake or genuine apparently on saying.
That is their opinion, my lord, because
Admitted.
no, he has not admitted. He says, as an insurance officer, how I can say that something is true or correct. That he has said.
That's why, Your Lordship, the owner of the vehicle ought to have been examined by the insurance company.
Okay,
They
it is
filed-
not possible to say on.
And last admitted, it is fact that we are liable to take compensation if the court order.
Yes,
Yes.
that is there because
So
that is
the
an
owner
accepted
was not
situation.
Anyway, you can continue.
We never say about the
Anyway, so you have, this is the observation
yes.
that the owner has failed, the insurer has failed to prove the negligence of the driver. Anyway, next.
My lord, so far. My first witness also, DW1, that is in page 17, he has also stated that he is an investigator, and while having the details of the driving license, he went for verification of the same. And he found from PVD, Bongaigaon, Assam, that the said driving license was not issued.
Anyway, this
My lord,
investigator
thing-
or the insurance authority cannot say whether it is fake or genuine. They have to verify from the
Yes,
RTA.
always.
So that is done.
Always. Now the question remains, my lord is aware about the section 74 of the Evidence Act because the document issued by a government office in the course of his activity, and that too also in a case of an RTI, that is supposed to be a public document, and that will also be exhibited, and that has been exhibited. The question of then the documentary value of exhibiting some exhibit A, B, C can be simply shut off by saying that it has been just simply been exhibited without any evidentiary value. My lord, it comes in 14A, 19A. I'm so sorry. Page 19A.
Yes.
Last, I mean in the middle, 1, 2, 3, 4, 4 line. Line 4. This is the letter issued by the Public Information Officer and Motor Vehicles Inspector, Bongaigaon District Transport Office, Bongaigaon, Assam. Let this be marked as Exhibit B. This is the certified copy of the insurance policy of the alleged offending vehicle. Let it be marked as Exhibit. I think it would be C, my lord.
Yes.
This is the email upon the investigator that he was appointed. Let it be marked as Exhibit D. Now, these are the documents that those were exhibited, and while exhibiting, that has not been objected. Nowhere it is stated that it is objected.
Right.
Had that been objected, the question of proving that document could have come. It has not been objected by the applicant. So therefore, it goes as unrebutted. If something goes unrebutted, the evidentiary value of the document has to be taken into by the learned court and also by the honorable court. This is my respectful submission. Here, this is the case that has happened. So therefore, my respectful submission is the right of pay and recovery as it has been provided in different verdict of the honorable courts and also in terms of Swaran that has been there, my lord. And although I should not have stated anything, but I just make an request or respectful submission before your lordships that 1 lakh each for minors have been allowed.
As consortium.
No, not consortium, consortium to the widow, and then to the mother 50,000, and for the mental pain and agony. On that ground,
Total compensation awarded is how much?
it was
17 lakhs.
It was like that.
17 lakh.
Yes, that will also earn an interest of
300, 500.
yes, that will also earn an interest of 6%.
So consortium and
Consortium allowed.
loss of estate and funeral.
That has all been allowed. I am not on this.
So
I am
2 lakh is on
simply
what heading?
1 lakh of two for mental pain and agony to each and every minors. There in the Pranay Seti, 1 lakh has been awarded to the minors. My lord, if it is so the principal, then
1 lakh is awarded to minor.
1 lakh was awarded by Pranay Seti
Yes.
to the to the minors consolidatedly. Now, if my lord, I have a son and I die, and thereafter that son gets 1 lakh. If I got 10 minors, then the 10 minors will get 10 lakhs. That should be the principle. But the question is not that. Question is, Pranay Seti says that minors have to be provided with certain mental pain and agony. We are on the way, or the Honorable Court will assess it on the total quantum that is there.
Consortium, parental consortium is not awarded.
Consortium allowed it. A
That
consortium.
is spousal consortium.
Yes.
No parental consortium.
Parental consortium has been allowed. How allowed? That each and every minor was allowed 1 lakh each.
And this filial consortium?
That was 1 lakh that has been awarded. And those, I'm not on this.
So yes, you are challenging what? Which
I'm saying that why can this be said that I do have multiple minor child, so I will have an opportunity. I mean, I do not say like that in such a manner.
All children should be no.
Yes. So the
all children request care.
Yes. No, I don't say that they all request care. That the minor.
So you see, loss of this near relation cannot be compensated. So whatever court thinks just and reasonable, that is awarded.
Yes. So can it be
held in different judicial pronouncements?
Yes, on each and every person. I mean, each and every minors.
So there cannot be discrimination. It can be from 1 lakh. It can be at best 50,000. That can be.
What can be? I don't.
But all are to be provided. If you have to provide one minor,
my lord, I am on a simple principle that the more child I do have, I also close my brief. I do have more child I do have, the more would be the compensations. And if I do have a single child,
the more child you have, the personal deduction would be less. But if you have, suppose you see the personal deduction,
yes,
1/4, 1/5,
1/4 is there,
and 1/3 is in usual.
I am not on that also, because the widow is there, the mother is there. So these two.
Anyway, you see, our principle is we have to follow Pranay Seti.
Yes.
Pranay Seti does not say consortium.
Yes, I just mentioned this. It is up to this honorable court. But
according to you, compensation awarded is excessive.
On that aspect only.
Okay.
Not on other aspect.
Compensation awarded is how much? 17 lakh?
17 lakh 3,500.
How much?
17 lakhs 3,500.
I do not otherwise object to any part of it.
Okay. Yes, can you conclude today?
Yes, Your Lordship. Your Lordship, I don't have any objection, Your Lordship, with pay and recovery, because Your Lordship, the London judge says the owner was not examined. It is not come to the knowledge of the court whether the owner had the conscious knowledge about the fake driving license. You see, in the chair state, Your Lordship, there is nothing that the license was fake. Only after the report or inquiry of the insurance company, they have come with the point that the license was fake. But Your Lordship, these are the claimants. They are the poor person, Your Lordship. They can pay and they can recover it from the owner. So I have shown up, Your Lordship, already Your Lordship held that in one of my cases, Your Lordship, in Your Lordship, that after examining the owner, they could have. First, they have to pay it.
We will pay, my lord. There is no question that we won't pay, and it is not my submission. We will pay, and we have already deposited
Though your
the
lordship-
entire awarded sum.
Though your lordship, whether it is a public document or not, there is a question. Because your lordship, no official formality has been examined. Whether the document was fake or original, the letter that was submitted, though that is questionable. But in spite of that, your lordship, I am accepting that. So let they pay and recover.
Yes, record an order. Learned advocates for the parties are present, heard learned advocates. Hearing is concluded. Let this matter appear for judgment on 18/8/2026.
Lordship, the consortium given to the children, your lordship, that was based on Rajesh versus Rajvi, the 2003 judges bench of Supreme Court.
So probably Pranay Shetty has not considered that.
No, Pranay Shetty also at that time, Pranay Shetty was not there. At that time,
subsequently-
the three judges bench was the law of the land.
So when Pranay Shetty, when the matter came before Pranay Shetty, the Honorable Supreme Court did not accept the issue of
Your lordship, your lordship.
this parental care and all
My
these things.
submission, your lordship, some benefit accrued in favor of the minors.
As per Pranay Shetty.
I'm not saying that why for, but minors, your lordship. That kindly consider that, your lordship. The benefit accrued in favor of the minor in view of the three judges bench of the Supreme Court.
Oh.
That was the law of the land at that time, and that was followed by every court at that time.
Let it be CAB then, my lord, whenever your lordship feels.
No. I've fixed a date. That
Yes,
is
lordship.
18/8
18/8.
for judgment.
Interest is 9%, that should be 6%, your lordship.
Yes, interest awarded is 9%.
9%. It should be
Yes, that has to be
6%.
reduced.
That I have said.
6%, your lordship.